All rise. Court is now in session. Although visited before the court of near Honorable Judge Chase Simpson presiding.
You may be seated. Mr. Cook.
Morning, Your Honor. Raymond Cook for the people. Your Honor, the people would waive any potential conflict between the Honorable Court and the Office of the Public Defender. While the people do not believe that any such conflict exists, we make this waiver in the avoidance of all doubt.
Thank you, sir. Ms. Paternity.
Good morning.
Good morning.
Assistant Public Defender Lauren Paternity, the Public Defender's Office likewise does not believe the conflict exists, but if one does, we also waive.
Thank you. Court for its part also does not believe there's a conflict either, and in Michigan rules or the cases decided they're under to the extent a conflict does exist, given the waivers, court will consent to hear the matters. Court does call the case of the people of the state of Michigan versus Donald Ray Baker.
And Senior Assistant Public Defender representing Mr. Baker. Mr. Baker, would you please state your name for the record, please?
Donald Baker.
Got it. Okay. What are we doing?
Your Honor, Mr. Baker is requesting a preliminary exam.
All right. All right. Anyway. Discovery is complete.
As far as I know, Your Honor.
And we would normally be setting for the 18th. What facility are you in, sir?
Don't.
Got it. We're gonna have to give how much time?
He needs 4 weeks, is my understanding.
It's 4 weeks out. Jeez. Go September 1. Would people have their witnesses available September 1st?
That's true. I think the discovery is not complete. I believe that his email being to go requesting some video. So
And maybe can okay.
if there's.
So, no. Is there some additional video for this matter?
I'm going to request some from agency. I'm not sure if they have it in there.
Okay. Then, Your Honor, could we keep the 9/1 preliminary exam date and I'll follow up with Ms. Stover?
I will indicate that video missing, no adjournment would be granted based upon that video not being present. Preliminary examination in person, September 1st, 2026, 9 a.m. before Judge Barr.
Thank you.
Continued. Court does call the cases of the people versus Matthew Gibbons.
Assistant Public Defender Hannah Appleton on behalf of Mr. Gibbons.
There are 8 cases.
Yes. Mr. Gibbons, can you state your name for the record?
Matthew Gibbons.
Thank you.
Oh, there he is.
Your Honor, I submitted a visitation application to his facility. I'm waiting to hear back to schedule a visit. So I would need an adjournment.
All right. How long are they indeed now?
How long?
Yeah.
Um,
You don't know that.
I don't know.
Why don't I then, he's got a number of cases here. Why don't I adjourn this out then to September 3rd? All right. All of these matters will be adjourned to September 3rd, 2026, 9 a.m. All right.
Thank you.
I'll need a green sheet.
Oh, I have it right here. I forgot I didn't turn them in.
Court does call the case versus President. And
That's good morning, Your Honor.
Like that name sounds
there
familiar.
are 184 cases.
We're gonna speed right through them, Judge.
Not at this rate.
Good morning, Judge. Assistant Public Defender Chinati Kyriakin-Rulli on behalf of Mr. Jason Burton, who's approaching.
Your name, sir?
Jason Burton.
Judge, we'd like to set this matter for preliminary exam, please.
Discovery is complete.
Yes, to our knowledge, Judge.
People have their witnesses available the 18th. Preliminary examination in person, August 18th, 2026, 9 a.m. before Judge Moore. Bond will continue. Thank you.
Thank you, Judge. Judge, can we make a note that he's gonna need headphones for the next hearing, please? But I will go and tell him everything that just happened.
I'm gonna suggest at the exam, just make sure that the court recorder knows
Okay,
that, and then we'll.
yes, Judge.
Court calls case People versus Wyona Harvey. Good morning.
Good morning. This is Public Defender Lauren Perry on behalf of Miss Harvey, who's appearing from Kalamazoo Psychiatric Hospital. Miss Harvey, can you state your name?
Wyona Harvey.
All right, I have a August 5th report from CPF.
That's correct, Your Honor. It states that she is still incompetent but restorable, so I'd ask for an adjournment. Yes, please.
I'll set a competency hearing review date, give me 90.
November 5th.
November 5th, 2026, 9 a.m. Yes,
Thank you, Your Honor.
all right, bond continued. Thank you, ma'am. Court calls case People versus Choya Horton.
Bring it over to you, Your Honor. Sound Shannon. And, Toya Morgan.
Did they get them? And
Listen.
got them, yeah. Horton, can you state your name, please?
Troy Dean Horton.
Your Honor, I'm requesting a 2-week adjournment. I did not get through the clearance portion of my attempt to interview with him. But I do believe that I have successfully completed it, so I will be able to interview with him.
All right, well, I'm gonna go 3 weeks out. Probable cause conference will be adjourned August 27th, 2026, 9 a.m. Bond continued.
Thank you so much, Your Honor.
Thank you. Thank you, Mr. Horton.
Thank you, Your Honor.
Court calls the case People versus Angel Patel, 2 cases.
Assistant Public Defender Zach Vinny with and on behalf of Mr. Martell, who is, I believe, present via Zoom.
Got it.
Oh, that works. Can you please state your name?
Angel Martel.
State your name, please.
State it again, sir.
Angel Martel.
Your Honor, the court should be in receipt of a competency report. We would stipulate to the findings of that report and would request an adjournment.
Based upon a review of that report, the court and the stipulated evidence, court would find that the defendant is competent to stand trial. Specifically, that the defendant can understand the nature and objects of the proceedings against him and can rationally assist in his defense. Therefore, the defendant is deemed competent, and I've signed the order.
And Your Honor, we would request an adjournment for negotiations
But you want it set for what?
or set for a PCC.
Probable cause conference in this matter then will be set. How much? Marcus? I'll set it for August 20th. 2026, 9 a.m.
Thank you, Your Honor.
Got it. Court does call the case of Ibrahim Abdullah Al-Bassar.
Good morning, Your Honor. Kelma Dadush on behalf of Mr. Abdullah Al-Nasir. Can you please say your name for the record? Abraham Abdullah Al-Bafir.
I've called this case early, was down at our access point. My understanding is, first of all, tested positive. We're informed from community corrections. We haven't issued the bench warrant yet. For fentanyl, was that yesterday?
Yes.
That was yesterday. Our understanding also is that you've been using this morning.
No, that was wrong. I just had some stuff in my pockets from using. But that was the last thing. It just in my system.
Your Honor,
I don't.
there's still one question from the top.
I don't know that, I didn't. That. On.
Ask for an adjournment so that we get the bond.
Given the information from yesterday's morning, the his bond. In this case, counsel approach. Right, record should reflect we've had a bench conference in this case. What I will do is I will grant the adjournment based on the information the court has, subject to a motion by the defense at this time. Also, in viewing the defendant's case, I'll adjourn his probable cause for 2 weeks to the 20th, 2026 at 9. At this point, the defendant's bond is revoked. Defendant. Thank you, gentlemen.
Thank you, Your Honor.
Thank you. Let's call the case People versus Michael McKay.
For the people. Chairman Dadush, on behalf of Mr.
McKay, state your name, please.
Michael McKay.
Your Honor, I wanted to adjourn this case to finish plea negotiations with prosecution. I was also unable to meet with him. So, we're
Okay.
asking for
An adjournment.
adjournment. Yes.
I could do the 20th. Right there, or once 27.
It's just because I had never used this facility before, so they had to get me approved and everything. So someone should be able to speak with him.
I'm going to do this, Mr. McKay. I'm going to bring out to August 27th so the attorney can speak to you, okay?
All right.
27th, 9 a.m. Bond. Thank you, sir. Court calls case of the people, Ronnie Oliver.
Yes, Ronnie Oliver.
Morning, Your Honor. Jay Grant Miller, P 58658 on behalf of Ronnie Oliver, who should be on Zoom.
Zoomer here.
Mr. Oliver is in the round.
Yes to the MD.
Mr. Oliver, can you state your name, please?
Mr. Ronnie Oliver.
Gotcha. Okay, what are we doing?
Your Honor, at this point, I would request an adjournment. I've gone through all the steps to try and communicate with Mr. Oliver. I've been unable to do so. Mr. Oliver, my name is Grant Miller. I'm your attorney. You need to put me on the list so I can talk to you, sir.
Can you state your name again?
J. Grant Miller. Grant like the president, Miller like the beer.
Gotcha.
Your Honor, we're just requesting a brief adjournment so I could communicate with my client.
Okay.
I was still at the beer.
Kennedy, lost.
August. Anybody else? Sorry. No, it's okay. You try to find your way to weasel in there somewhere. August 27th, 2026, 9 a.m.
Thank you, Your Honor.
Bond will continue. Not a beer. Court calls the case, People versus Renee Williams. Oh. That's it.
Public defender representing Ms. Williams.
All right.
Yes.
Williams, can you state your name?
Yes, my name is Renee Williams.
Thank you. And what are we
Yes,
doing?
We are here for competency review today. The court is likely in receipt of a report indicating the defendant is competent and not responsible.
That from July 21st.
That's correct.
That date of the report, I don't recall the date we received it.
Yes, I have it from the 21st. So what are we gonna do on this?
Your Honor, I'd ask for 2 weeks so I can see if we're gonna full probate proceedings because she is in Kalamazoo, so I need to check into the jurisdictional issue.
No, Your Honor.
I'll adjourn the competency hearing then for 2 weeks. I'll adjourn that to 20th,
Thank you.
2026, 9 a.m.
Thank you, Your Honor.
Thank you. Bond will continue. All right. Thank you, Ms. Williams.
Thank you.
Oh, you're very welcome. Thank you.
Court calls case, People versus Ethan Miller.
Your Honor.
Apparently also related to the.
Board Judge.
What? Thank you.
Brian Bowling, Assistant Public Defender on behalf of Mr. Miller.
Oh, is she? Boom, boom room back there.
Morning. Can you state your name for the record, please?
Ethan Miller.
Thank you.
Judge, we're asking this matter be set for an exam. I believe all discovery to be complete. There is one issue with respect to some photographs, but this is indicated to me that she received them yesterday, so we should have them shortly. So we should be good on the exam date.
We'll have their witnesses available the 18th. Preliminary examination in person will be set August 18th, 2026, 9 a.m. before me. Bond will continue. Thank you.
Thank you, Judge.
Court calls case, People versus Donald Foreman.
People.
Assistant Public Defender Jay Bellinger on behalf of Mr. Foreman, who appears via Zoom via Jackson County. Mr. Foreman, can you please state your name for the record?
Donald Foreman.
And Your Honor, I'll just make it clear on the record, I have had an opportunity to speak with Ms. Beltis about the potential for an offer. She advises that no offer is going to be had down in the district court. For that reason, I talked to my client yesterday. My understanding is that he wishes to waive up to circuit court. Is that still true, Mr. Foreman?
Yeah.
I don't know that I've got Foreman.
He's there. I barely heard him when he said his name, Your Honor, but.
Mr. Foreman?
Yeah.
Oh, there he is. Okay. You're waiving your right to a preliminary examination?
Yeah.
Is that a yes, Mr. Foreman? Can you say yes if that's true?
Yeah.
Okay.
You understand that that's a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them. Do you understand that?
I do.
You'll have to speak up. Did you?
Yeah,
Okay. You understand that you won't have that hearing and that you'll proceed to circuit court for further resolution.
yeah,
Okay. People also waive their right. Preliminary examination having been waived, defendant is found over on the 2 felonies, 1 in each case with 2 misdemeanors following in each case.
Thank you, Your Honor. As to that, we acknowledge receipt of the information, wait formal reading, stand mute.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea as to all 6 counts. Pre-trial will be set for
25th at 1:30 with Judge Funky.
August 25th, 2026, 1:30.
Thank you.
Bond continued.
What's that?
Yes, momentarily. Yeah. Court does call the case People versus Tamika Slip.
Morning, Your Honor. Christina Costantino appearing with and on behalf of Tamika Schlip, who should be appearing via Zoom. Ms. Schlip, can you, the Michigan Department of Corrections, to unmute you and state your name for the court?
I heard things about you and a wonderful performance you gave in another courtroom.
Oh, thank you, Judge.
It was good.
No, oh, okay. A performance, no,
Thought I'd let you know.
Judge. For whatever that's worth.
Yeah,
I'll take it.
Miss Slip? We're trying to unmute. Okay, there you are.
Hi,
Hello. How you doing, Miss Slip? I'm wonderful. Doing great. Thank you.
Your Honor, this is. Judge, this is the date. This is the date and time set for a probable cause conference. We have had some negotiations between the prosecution and defense. A plea offer has been extended, but unfortunately, I have not been able to meet with Ms. Schlip. I have actually scheduled 3 different meetings with her, and she was unfortunately not brought to either of those meetings by the Michigan Department of Corrections. I have called, I have done a number of things to try and be able to meet with her, but unfortunately I haven't been able to prior to today's court date. So we are asking for a brief adjournment so that I can have an opportunity to discuss the plea offer with her. And Ms. Schlip, I hope that you heard that. I've tried to meet with you, but unfortunately I have not been able to. The Michigan Department of Corrections didn't bring you to my meetings with you, but I will be seeing you very soon.
I need to go get the mental health help.
I know, Ms. Schlip, and I'm.
Okay, Miss Slip. Miss Slip?
Yeah.
Okay, just listen. So your attorney's got to be, she's got to be able to meet with you, okay? All right, we're going to try to find a way to make that happen. What, 20th or 27th?
20th, please.
No, come
So,
on.
hey, Miss Slip?
I can't do
And
it anymore.
Ms. Schlip, if it helps.
Listen, I like jumped on my 14-yard dog because I didn't take my medication, and they wanted to shoot me on Tylenol, and I'm allergic to it. I got bruises, fucking blue marks all over me. I can't do this anymore. I need to go to the
Slip?
forensics.
Miss Slip? Miss Slip?
Yeah.
Okay.
Yes,
We've seen each other a couple of times. If I didn't think that this was the right thing to do, I wouldn't do it to you, okay?
I need to go to a mental health hospital.
Okay, we're gonna let
I need to go to KPA, just County Psychiatric, or the forensic center. I don't
Okay.
understand what I did wrong.
Okay, Miss Slap, here's what I'm gonna do. I'm gonna put this out 2 weeks like your attorney asked, and you're gonna get to talk to her. And then we're gonna try to
Okay.
make sure something happens on that date, okay?
You promise?
Miss Slap, I promise you, I'm gonna give everything I've got to make sure we get you through this, okay?
Are you sure?
I'm
Because
sure.
my cases they are done.
Miss
A
Slap, I've
million
never,
times.
Miss Slap, I've never let you down before, right? I don't plan on doing it now.
Okay, you promise?
Okay,
Do you pinky
So-
swear?
as much as I can promise, I promise, Miss Slip, okay?
I need to go get some
And Miss
real
Slip, think
milk.
about it. If nothing else, we get to see each other one more time, okay?
Okay.
All right.
I love you, Mr.
All right.
Linden.
Okay, we'll see.
Mr.
Okay, we'll see you on the 20th. All right?
20th, how many more days is that?
That's about 14 days.
Okay.
All right.
Thank you.
Thank you. You take care of
And
yourself,
God
Miss
bless
Slip.
and keep smiling.
Thank you very much, Your Honor.
You're welcome.
Thank you, Mr. Sonora.
Yes, ma'am.
Bye.
Bye-bye. Court calls the case, People versus Tariq Wilson.
Tariq Wilson.
Got it? Yep, we got you. Okay, go ahead.
Jordan, Senior Assistant Public Defender representing Mr. Wilson.
All right, what are we doing?
I'm just refreshing your memory. Your Honor, I met with Mr. Wilson yesterday and we had an opportunity to begin discussing his case. I'm asking for an adjournment so that we can have some additional time to talk about his options.
All right. You need additional time to talk with him about. You want the 20th or 20th or 27th?
The 20th, please.
20th. Probable cause conference will be adjourned August 20th, 2026, 9 a.m. Bond will continue. All right. Thank you, Mr. Wilson.
Thank you. Have a good one.
Court does call case People versus Jason Bailish. Excuse me.
Attorney General's.
Good morning, Your Honor. I'm Special Assistant Attorney General Mitchell Wood for the people.
Good morning, sir.
Good morning, Your Honor. Assistant Public Defender Nicholas Bukovich on behalf of Mr. Bailish, who should be coming.
You're just gonna have to be spread out throughout the day. Got a message. Your name, sir?
Jason Eric Bailish.
All right, you're waiving.
Yes, we are, Your Honor.
Sir, you're waiving your right to a preliminary examination.
Yes.
You understand that that's a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
Yes, sir.
You understand you'll not have that hearing. You'll proceed to circuit court for further resolution.
I do.
The people also waive their right.
Yes, Your Honor.
Preliminary examination having been waived, defendants bound over to circuit court on both counts. Mr. Bucket.
Waive the formal reading of the complaint and be standing mute.
Defendant having waived formal reading, standing mute. Court will enter not guilty pleas to both charges. Pretrial will be set for
17th at 1:30 with Judge Hamud.
August 17th, 2026, 1:30 before Judge Hamud.
And,
Thank you very much,
one
Your
thing-
Honor.
Thank you. What? Yes, Mr. Bukovich.
one thing for the honor, the rest of the honor, my client is waiving to pursue the offer of the AG in the circuit court, which would include waiving the habitual second offense notice on the complaint. I just wanted to put that on the record.
All right, very good. All right, thank you.
Honor.
Bond,
From the, she's waving it. I don't know what you're doing. She's waving.
ma'am, you're waving at me. What's your name?
Jamila Bounds, Bounds.
Gotcha. I'll call your case right now. Court does call the case. People versus Jimmy LeBounds.
Assistant Public Defender Hannah Apple appearing on behalf of Ms. Bounds. Ms. Bounds, will you state your name for the record?
Jamila Bounds.
Thank you. Your Honor, I do have a green sheet. We're asking for a brief adjournment. We have some plea negotiations that are taking place, and so hoping to reach a resolution.
During the matter, August 27th, 2026, 9 a.m. Bound, continue.
Thank you.
Right. Thank you, Ms. Bounds.
Thank you.
Court calls case, People versus Heather Booth.
Good afternoon, Your Honor. Raymond Cook for the people.
6 case. Yours.
And good morning, Your Honor. Sydney Rushing, appearing on behalf of Ms. Booth. I'm in case ending 0913.
Good morning, Your Honor. Jay Grant Miller, P58658 on behalf of Ms. Booth.
Assistant Public Defender Nicholas Buckovich on behalf of Ms. Booth.
We've got a trio of green sheets for you, Judge.
Your Honor, I believe Ms. Rushing's is the most legible, so I'd suggest you use.
I assume that.
And Your Honor, I didn't even write it. Ms. Constantino did, so that's why it's even more legible.
That's her writing. Why did she write it?
Judge, I was running a little bit late due to traffic, so of course she had my back just in case. You know, you called the case because Ms. Booth is second on the list. So I was a little worried there.
She's incredible.
Isn't she? Absolutely amazing.
Short, but incredible.
Judge,
All right.
big things come in small packages.
I'm sorry. I had to take the shot. I just took the shot. All right. And how much time did you need?
Judge, I know that her matter in Wayne County that we are kind of tracking to hope to get together is August 21st. So maybe the latter date in August or early.
Oh, great. Latter day, 27th would work.
That would work, Judge.
That would work.
All right. Ms. Booth, I'm going to adjourn all your matters out to August 27th, 2026.
Thank you. Thank you.
Thank you.
Have a good day.
Thank you, Your Honor.
Your Honor.
Court does call the case, People versus Sarah McCormick.
Good morning, Your Honor. Andrew Siddle on behalf of the defendant, Sarah McCormick.
McCormick, can you state your name, please? Oh, she's not unmuted yet.
Good morning, Sarah Lynn McCormick, Your Honor.
Thank you. Who's her attorney? Ben Zoom. All right. I have before me a plea sheet that indicates that the defendant would be pleading to the charge and added count 2 of use of a controlled substance, a 1-year offense. Upon our successful plea to that charge, count 1 would be dismissed. That's the court's full understanding of the agreement.
Correct, Your Honor.
Ma'am, can you raise your right hand to be sworn? Do you solemnly swear or affirm testimony you're about to give will be the truth, whole truth, nothing but the truth, so help you God?
I do. Yes, Your Honor.
State your name again for me, please.
Sarah Lynn McCormick.
All right. It's court's understanding that you're going to be pleading guilty to the charge of use of a controlled substance. That's a misdemeanor punishable by up to 1 year incarceration, $2,000 fine plus court cost. Do you understand that?
Yes, Your Honor.
All right. Understanding that, you still wish to plead guilty?
Yes, Your Honor.
And to that charge, how do you plead?
I would like to enter a no contest plea or guilty. I'm just having a hard time hearing.
You're having a hard time hearing. Okay.
I can hear you.
Ma'am?
No, I can hear you. I can hear you now. It's just in and out.
Okay. All right. I was looking at your reaction. Do you want to plead guilty to this charge?
Yes, Your Honor, if the plea is accepted by the court.
Okay, well, let's see. We'll go through the facts and we'll see if I can accept it, okay?
Yes, Your Honor.
All right, I've apprised you of the maximum penalties. So to that charge, how do you plead?
Guilty?
Okay. You understand that by pleading guilty, you'll not have a trial of any kind?
Yes, Your Honor.
All right. you had signed or had signed on your behalf an advice of rights form?
Yes, Your Honor.
Okay. Do you have any questions regarding any of those rights?
No, Your Honor.
You understand that you're giving or waiving those giving up or waiving those rights, particularly your trial rights under paragraph 5.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
You're not on probation or parole at this time, is that correct?
No, Your Honor, not at all. But I did speak with MDOC parole board, and given the PR bond, I'm incarcerated due to this case not being adjudicated. That's why I'm still in custody.
Gotcha. Okay.
Yes, sir. Yes, Your Honor.
Has anybody promised you anything other than what's been stated here today to get you to plea?
No, sir, just the court, Your Honor.
What did the court promise you?
No, just what we're reviewing, what I'm reviewing with you.
Okay,
Judge.
what I said today.
Yes, Your Honor.
All right. Did anybody threatened you or coerced you in any way?
No, Your Honor.
You're doing this voluntarily and of your own free will?
I am, Your Honor.
And also because you believe that you're guilty of this offense?
I do. I just wish to move to immediate sentencing. Yes.
Okay. I got to accept the plea. Just hold on. I got to take it step by step. Okay?
Oh, sorry, Your Honor.
No, it's okay, but you're pleading guilty because you believe that you are guilty.
Yes, Your Honor.
All right. On the date of January 12th, 2025, at the location of the Huron Valley Correctional Facility, were you in possession of clonopin?
Unfortunately, I was, Your Honor.
And you did not have a prescription for that, is that correct?
Not in custody, Your Honor. No.
Okay. And did you use it?
I did. I used it for 15 years, but I wasn't permitted to use it in Huron Valley, Your Honor.
Okay, while you were in Huron Valley, did you use the clonopin that you had that day?
I did, Your Honor. Yes.
Thank you.
Sorry.
Counsel, have I complied with the court ruling? Would it be proper to accept this defendant's plea?
Yes, Your Honor. Thank you.
Court will accept the defendant's plea to count 2. Count 1 is dismissed. Ma'am, is there anything you want to say before I impose sentence?
I just want to apologize for my inability to cope properly and the horrible decision that I made to use that with respect to my anxiety condition. I did not have permission to use that. I could have put myself, staff, or others at risk with that, Your Honor, and it has caused extenuating collateral consequences significantly in life, and I regret this probably more than anything. It's the worst decision I've ever done, honestly.
Okay, how long have you been in?
My sentence was for 7 months. I've been here 2 years, Your Honor. I was supposed to leave last July and then June 20.
Okay.
June 20.
It's the sentence of the court. Since his statutory minimum is $125, 365 days in jail, credit 365 served. All right, you're all set. This case has now been adjudicated. Good luck to you, ma'am.
Thank you so much, Your Honor. Thank you, Andrew. Thank you.
Thank you, Judge.
Thank you, Your Honor.
Sarah.
Have a good day. Thank you. God bless you all. Thank you. Take care.
And court calls the case, People versus Dominic Brewer.
Morning, Your Honor. Raymond Cook for the people.
Good morning, Coach Carbondale. On behalf of Mr. Brewer, who's approaching the podium, will be standing next to me. Mr. Brewer, when you get up here, please state your name for the record.
Dominic Brewer.
Your Honor, today is the date and time set for a probable cause conference. We are working on discovery. It's my understanding that the people are working on getting the video. I'll leave it to Mr. Clinton.
I got an email this morning from the sheriff saying that the videos were processing and being uploaded. I don't see them yet in our system, but I'm hoping by the end of the day that should process.
Got it.
And I have handed up for the record the green.
Turn the matter to August 27th, 2026, 9 a.m.
Thank you, Judge.
Thank you, sir. Court calls case People versus Scott Kidney.
Roberto on behalf of Mr. Kidney, but not with. Your Honor, we've catch up. So Mr. Kidney is currently in, last I knew he was in Livingston County. It's my understanding we tried to writ him out today, but they weren't able to produce him because he's in transport on a federal matter. The people have tendered an offer of a civil infraction, which I have been given his permission to admit responsibility on his behalf.
Oh,
That's fair.
wow.
Yep, so we're pleading this felony down to one civil infraction for violation of the seatbelt law under 257.710 and no registration under 257.223. Both carry no points. In exchange, the people counts 1 and 2.
So count 3, the civil infraction of what?
Violation of safety belt law.
Can you get fines for me on? And count 4 is what?
No registration under 257.223.
No proof of registration.
Yes, Judge.
All right. And on behalf of your client, you do admit responsibility to the fact that these offenses occurred on or about August 23rd, 2024 in Pittsfield Township, Washington County, State of Michigan.
So admitted.
Right. Court will accept the admissions to counts 3 and 4. Counts 1 and 2 are dismissed. Count 3. 65. Really?
Yes.
All right. Fines and costs of $65 on count 3, and on count 4, what's that? 200?
120.
Close. Fines and costs of 120. I'll make those due and payable 30 days after release. Okay, thank you.
Thank you, Judge.
Court does call the case People versus Phoenix Barnes.
Good morning, Your Honor. Raymond Cook for the people.
Good morning, Your Honor. Christina Saxon for Phoenix Warrants.
Your name, sir?
Mel
Bradburn. Barnes, what's your name, sir?
Mel Bradburn.
All right, just hold him there because we're having enough problems getting people out. We'll just find the file.
That's Mr. Miller's case, Your Honor.
Okay, I apologize. So this is Mr. Bradburn,
Okay,
which is.
So
the
I'll
gentleman in
call-
front of-
I'll call the case of the People versus Jamal Bradburn. You're good, sir. Where's the beer guy? Oh, here he is.
Morning, Your Honor. Jay Gray Miller, P5865, on behalf of Mr. Bradburn.
He's already stated his. All right, what are we doing?
Your Honor, as last time we were here, we're still waiting for that one crucial piece we need of evidence to set this for exam. It's my understanding we still don't have that.
What is the
report, Your Honor?
It's
A legible copy.
They do the carbon copies, and unfortunately, when they scan it at times.
And we still don't have it? Well, let me ask this. Is it your copy? Can you read your copy? Or you can't read your copy?
As much as I need to.
But you can't read your copy?
Your Honor, and if the court remembers up last, we were here at the sidebar. The one crucial part where it says no damage is checked no on the copy I can read, but the rest of it's kind of illegible. So it's not very fruitful for defense to be able to hold an exam. Because it appears to list no damage to the victim from my copy.
Is this the only thing holding him?
Yes, Your Honor.
And I realize, Mr. Kennedy, you made the request. Do we know what the delay is?
Working with hospital. Get another copy of that same report. I don't know what the delay is.
So do they want to be subpoenaed in? I mean, I
I'm doubtful,
I
Your
will
Honor.
do what needs to I mean, he can't sit here And that's. I mean, I'm not blaming you, I'm just saying. People need to understand. So here's what I'm gonna do. Realizing that discovery is not complete, but there's just this one issue, I'm gonna set an exam. For him. Would you have your witnesses available the 18th?
We'll do our best.
Preliminary examination in person will be set August 18th, 2020, 9 a.m. for me. And Mr. Miller, if you want a subpoena for the holder of those records, you can submit it to my office for my signature.
Thank you, Your Honor.
Court calls case versus Gene Hosford.
Morning, Your Honor, members of the people.
Morning, Your Honor. Dan Guerin, on behalf of Ms. Hosford, stepping forward. Gene, can you state your name?
Gene Hosford?
Thank you.
Your Honor, there should be a green sheet in your file. I'm asking for an adjournment. There appears to be negotiations. We're waiting on a restitution number. And of course, I have a travel request at the appropriate time.
Oh, you can go wherever you want.
Thank you.
Oh, no.
My wife will appreciate that. Thank you.
What do you want, the 27th or the 3rd?
3rd, please.
3rd. Adjourn the matter out to September 3rd, 2026, 9 a.m. as to bond.
Your Honor, Ms. Hosford is asking to go to a pre-planned trip to New Mexico from the 18th of August to the 30th of August. Beautiful
state.
Beautiful state indeed.
From what time?
8th to the 30th, Your Honor.
Okay. It's going to see the state.
Anniversary trip and
well,
go to the Santa Fe Opera. My interning.
Your granddaughter, is it?
Yeah.
Fantastic. Well, congratulations on the anniversary and permission to travel.
Oh, it's not my anniversary.
No.
Oh. No, I do that. I celebrate anniversaries all over.
Sure.
It's okay, man. Permission to travel.
Thank you, Your Honor.
Thank you.
Thank you. Court calls the case of the people versus Dontrell Smith.
Good afternoon, Your Honor, or good morning, Your Honor.
Assistant Public Defender Zach Finney with it on behalf of Mr. Smith, who is present via Zoom, I appear.
Mr. Smith, can you state your name, please?
Dontrell Smith.
Got it.
Your Honor, you should be in possession of a report that Mr. Smith is still incompetent but restorable to stand.
July 21st.
Yes, Your Honor. So we would be requesting an adjournment for that purpose.
All right.
Can I have a
Court will find that he is still incompetent to stand trial. Would set a competent
that's so
hearing
that might be the
for November 5th, 2026, 9 a.m. bond contingency.
Thank you, Your Honor.
Court calls case people versus Phoenix Orange.
Morning, Your Honor, Raymond Cook for the people.
Good morning, Your Honor. Christina Saxon for Phoenix Born.
Your name?
Phoenix Bornes.
All right, what are we doing?
Your Honor, I have secured the evaluator.
Ms. Saxon,
who's
I can't make
waiting
out
on
what you're
the
saying. You broke
approval
up.
From. Your Honor, I have the evaluator who can do his evaluation on Friday, but I'm waiting on the approval from IDSO.
All right, so what would you like me to do? Because we still haven't addressed his bond violation.
Could we have to September 3rd?
All right.
Your Honor. Yeah, I have a house arrest.
Me what?
House arrest.
I get put on house arrest, bond.
You be put on house arrest? I'll entertain a motion, but I'll entertain a written motion because I've got to still address this bond violation. I've not addressed that yet.
Okay, Your Honor. Understood.
So something may be set before the date I'm about to give you, but I'll adjourn the PCC and the bond violation at this time to September 3rd, 2026, 9 a.m. Bond continued. Thank you.
Thank you, Your Honor.
Good morning. Court calls the case, People versus Robert Brad.
Have call this for the people.
Morning again, Your Honor. Dan here on behalf of Mr. Brad, please step in.
Robert Branch.
Yeah, I'm asking for an adjourned probable cause date. If I could have 4 weeks, my client's going to begin some serious outpatient program and I'd like to get to the prosecutor.
Third.
Please.
Adjourn the matter to September 3rd, 2026, and bond continue.
Thank you, Your Honor.
Thank you. Court calls case, People versus Rennie Brooks.
Good morning, Your Honor. Trovius on behalf of Mr. Brooks. He's in custody.
I know. Is he physically?
Your Honor, we're going to be asking to waive the exam.
Well, I'm gonna need client. Taking a while. It's not any of these officers' fault. This is gonna be a long day.
Mr. Brooks, approach the podium, state your name. Rennie Brooks.
Thank you. He's waiving his preliminary examination.
Yes, Your Honor, you got to sign.
Is that correct, sir?
Yes, sir.
You understand that that's a procedure the people show by probable cause that the offenses alleged were committed and that you committed them.
Yes, sir.
You understand you'll not have that hearing and that you'll proceed to circuit court for further resolution.
Yes, sir.
You will also waive their right. Preliminary examination having been waived, defendant is bound over to circuit court on count 1 with 2 following. Mr. Starr.
While we stand mute, waive the formal reading.
Defendant having waived formal reading, standing mute to both counts, court will enter a not guilty plea. Pretrial will be set for
1:30 with Judge Humphrey.
August 25th,
Yes.
2026, 1:30.
Thank you, Your Honor.
Bond continued. Yes, you may. Court does call the case, People versus Thomas O'Neill.
Thank you, over for the people, Your Honor.
Morning, Your Honor. On behalf of Mr. O'Neill, he's here by Zoom or should be.
He is there.
He is. Mr. O'Neill, can you state your name, please?
Thomas O'Neill.
Thank you.
Your Honor, I'm asking for an adjournment to September 3rd. There's a ton of discovery to get through. I do have one bond request at the appropriate time.
Time is really.
I figured that was.
Okay. Probable cause conference, I'll adjourn to September 3rd, 2026, 9 a.m. Yes, as to bond.
Your Honor, his work occasionally takes him to the lovely state of Ohio. He's asking to leave the state of Michigan next week twice. That'd be Wednesday and Friday, I believe, to go to Ohio. Is that correct, Mr. O'Neill, those days?
That's correct.
Ohio?
Yes, sir.
What part?
Toledo.
That's not really Ohio. It's disputed. It's really ours. We give them the UP back to Wisconsin, take Toledo. I solved the whole thing if I had been alone. Defendant may travel to Ohio for work.
Thank you, Your Honor.
Thank you.
Good luck to you. Come back across the border.
Thanks, Your
Honor. Bond will continue. I did it right. No. Court does call the case of the People versus Cortez Bryant. Physical.
Carolyn Foster Tucker on behalf of Cortez Bryant.
They're not going to be able to move them any faster. I mean, it's not their fault, I realize, but it's going to be all day. Sir, come on up.
You see your name?
What's your name?
Cortez Bryant.
Thank you. What are we doing?
We're requesting a preliminary exam,
Discovery is complete.
to my knowledge.
People have their witnesses available the eighteenth. Court preliminary examination will be set the eighteenth of August, 9 a.m. before Judge Moore.
Thank you, Your Honor.
Thank you. Bond continues. Court calls case People versus Patricia. Is it Arwell? I said that wrong, I know, but
Morning, Your Honor. J. Grant Miller, P 58658. On behalf of Miss Agrawal, who's present. Might be just out in the hallway, Your Honor, if I could go.
yeah, because I don't have anything else to do. No, it's not. Nothing is Miss Gaines' phone. Ever.
For the record.
Trisha Agrawal.
Thank you.
Your Honor, I'm asking for an adjournment so we can discuss possible settlement negotiations with the people.
August 27th, 2026, 9 a.m. Bond continued.
Thank you, Your Honor.
Oh,
Court calls case People versus Logan Livingston.
Assistant Public Defendant Nick Buckovich on behalf of Mr. Livingston.
You what? Where is he?
In Zoom, but he can't hear you because he's not connected to audio. It's this one.
It's like everything here. People can't hear me. I got things to say about Bellinger. Court calls case People versus Julio Burton.
Morning, Your Honor. Raymond Cook for the people.
Good morning, Your Honor. Edward Dukas on behalf of Cleo Burton.
Leo Barton.
Your Honor, I'm waiting on some video discovery. I'd ask for a brief adjournment and to address bond at the appropriate time.
26, 9 a.m.
Oh, if I could address bond.
Yes.
Oh, okay. Asking for $1,000, 10% bond. He's being held on another matter of circuit court and he has a PR bond right now.
He has what?
He has a PR bond currently
On the circuit court.
on this case. He's being held without.
Asking me to up his bond.
Yes.
All right, I'll adjust his bond to a 10%. This man.
All
right. Court does call the case People versus Dion Baldwin.
Morning, Your Honor. Raymond Cook for the people.
And good morning, Your Honor. Assistant Public Defender, Chandra Carey, I can really, on behalf of Mr. Dion Baldwin, that's who we called, right, Judge? Yes, Dion Baldwin on Zoom. Mr. Baldwin.
Hey,
could you state
Judge.
your-
How you doing, Mr. Baldwin?
Good.
All right.
Judge, we're here for a competency review. I don't have my notes, but the last time we were here, he was found incompetent but restorable within the time frame. We received a letter from Forensic Center just basically stating that they are waiting for a bed. I have not received any new updates from, I think that was June, was that June?
I'm seeing, we got a letter dated July 29th, 2026, indicating the defendant is still incompetent and likely to attain competence.
July 29th?
I don't have that.
I don't have that either. So that letter indicates that he is still incompetent.
And likely to attain competence in the statutory.
Okay, then based upon that, and I'll receive a copy of that, I'll set this for a review. Competency review, November 5th, 2026, 9 a.m. Bond continued.
Can we,
Thank you, Judge.
can we discuss bond?
Sure.
I was requesting $5,000 surety.
Receiving treat.
Anybody with a P number want to speak up?
No, I was just like, sure, yes.
And
Your Honor, I did.
tons of them out here from anybody.
That's right.
Go ahead.
Sorry about that, Judge. I did have an opportunity to meet with Mr. Baldwin. He gave me some information that he wanted us to address with bond, but I guess what I was confused about was whether or not he was actually receiving treatment now while in the jail towards regaining his competency. Obviously, the letter that Mr. Cook read to believe that that is the case. Mr. Baldwin says, and I can tell he's been doing much better. I've been working with him for a few months now, Judge, and the clarity that he has, linear conversations, there's a lot that has changed from when we first met. He says that he feels a lot happier. He has been able to regain connections with his family. They have been supporting him while in the jail with commissary and other things of that nature. He was ready to start discussing the case in a realistic manner and was ready to start putting forth a plan. I did tell him that I would hold off on putting a plan together in regards to the case until we can get confirmation that he is competent. He states that he has some funds available to him that he would like to use to assist with.
All that was a long, wind up to the bond argument. Yeah, go ahead.
Funds that he would be able to use towards his housing. He understands what the issue that brought him into jail is. He knows the no contacts and the no go-tos. He assures us that he would be able to abide by whatever bond conditions the court places on him. So we're asking, Your Honor, if the court could consider allowing him to continue receiving his treatment from out of the jail, if that is possible.
Well, would he be? There any response?
I would have concerns about the defendant's ability to remain compliant while on bond and continue his treatment. If he's still incompetent to understand the proceedings, I don't know if he'd be able to understand the bond conditions when in custody and still incompetent. So I would ask that bond will be the same until he is able to be restored to competency and we can have trust that he will abide by the conditions set by the court.
Okay, here's what I'm gonna do, because I'm not sure I heard everything. Not sure I have a full picture of what his treatment regimen. So it's almost impossible for me to assess whether or not he could potentially manage that outside of the facility. So what I'm gonna do, and so Mr. Baldwin, just listen to me. I'm gonna deny the request to change your bond at this time. Counsel, if you deem it appropriate, file a motion with all of that information, and then I will look at it again. Okay?
We do that, Judge.
Got that, Mr. Baldwin?
Thanks.
Thank you. Take care.
Yes.
Thank you so much, Judge.
Really? We still like your husband better. Court calls the case, People versus Morel Brown. Just saying. Say it whenever I can. Is it Friday?
Maybe Friday too.
Yes, sir.
Ellis Friedman for Merrill Brown. Your Honor,
Sir. Or Brown.
Your Honor, I got discovery last night about 4:30 and it's not complete, but I don't believe it. I'd like to have time to review it before further.
Right. Want the 20th or 27th?
I saw what you had on the 20th and that's a hard no.
The 20th is a hard no. So you want the 26th? Probable cause conference will be adjourned. August 27th. I almost should make you come. 9 a.m. Bond continued. Thank you. Not just a no, it was a hard. Court does call the case, People versus Logan Livingston.
Logan Livingston, Your Honor. And Assistant Public Defendant Nicholas Buckovich on behalf of Mr. Livingston.
Requesting an adjournment.
Yes, I am, Your Honor. Requesting an adjournment to work on some further negotiations as Mr. Livingston is currently in Wayne County Jail. I would also like to briefly address bond when appropriate.
Of course. Will he still be in on the 27th or?
Yes, I believe so.
All right.
The bond request is very simple, Your Honor.
Pardon?
The bond request is very simple.
What is it?
Currently, he has PR bonds in this matter. He thought he was gonna be released from Wayne County on a tether. However, that is not happening. So he would just ask for low cash bonds, so he need credit for time served as he's out there.
Probable cause conference, August 27, 2026. Bond will be readjusted to a $1,000, 10%. Thank you.
Thank you, Your Honor.
Court calls case People versus Christopher Gilmore.
Good morning, Your Honor. Adam Dreer with and on behalf of Mr. Gilmore, who's standing to my right.
Your name, sir?
Chase Gilmore.
Your Honor, today is the date and time set for a probable cause conference.
Right. No, go ahead.
Mr. Gilmore is demanding a preliminary examination. We ask to be set for next week.
Yeah, we'll look for there's outstanding discovery that defense requested. It was a 911 call, some other media, a related police report that was made earlier in the day, and anything associated with that report. I believe that I do not have the other media as of today. I did put in requests for those. And I would ask for I believe next week is a little quick to get witnesses on present, so I have for the normal date of 18. If we are setting it, but there is.
That's the only thing holding him?
Yes, or he has a retail fraud that has a retail fraud third, but I believe that case is.
Out of bond.
He was arraigned on it.
He was arraigned on it already?
Next up on the 12th of August.
Your Honor, if I may respond.
Go ahead.
I would outline that MCL 766.4 does require that a preliminary exam have already been set. There's also strict time limits in that. The prelim must be held 5 to 7 days after.
You want a prelim? I'm going to give you a prelim.
Yes, Your Honor.
All right. Discovery complete.
No, Your Honor.
Will not get an adjournment on the prelim if you don't have discovery. I want you to understand that because we do things a little bit different here in Washtenaw County. You understand what I'm saying?
Yes, Your Honor.
Put it on mine. Give me a date. He wants it, we'll do it. Well, no, I need before then. He wants it next week. Give me it next week for me.
11.
Okay. Preliminary examination in person will be August 11th, 2026, 2 p.m. before me.
Yes, Your Honor.
Thank you, Your Honor.
Bond continued.
Minute.
They're giggling. He almost failed. He's like, maybe.
So who wants to go next?
Joy.
Court calls the case People versus Nia Lee.
Great. I'll take one for the team, guys. Fine. Fine. I can be a team player. Christina Costantino appearing with and on behalf of Nia Lee, who should be.
The only person they could have sent up besides Joy. But I won't start.
Lee should be present via Zoom. Ms. Lee, can you please unmute, turn your camera on and state your name for the court?
Nia Lee.
Okay, there you are. Okay, what are we doing?
Your Honor, this is date and time set for PCC. I have spoken with my client about her right to have a preliminary examination in this matter, and that at a preliminary examination, the people must prove probable cause that she committed the crime alleged. After discussing that thoroughly with her, she does wish to waive her right to have a preliminary examination and understands this matter would be bound over to circuit court.
Lee, is all of that correct?
Yes.
All right. People also waive their right. Preliminary examination having been waived, defendants bound over to circuit court on the single count. Ms. Constantino.
Your Honor, she wishes to stand mute and waive a reading of the charges.
And then having waived for a reading, standing mute, court will enter a not guilty plea. Pretrial will be set for
Judge Collins.
September 30th, 2026, 1:30 before Judge Conlon.
30th.
30th. Bond will continue.
Thank you very much, Judge.
And
Thank
yes,
you.
Blondie Feltes, before you ask, you may sign it.
Thank you, Judge. Have a good rest of your day. I'm out of your hair.
You're out? It's gonna get rough. Thank you, Ms. Constantino. You take care. Court does call the case. People versus Ayad Abulez.
Good morning, Your Honor.
Morning. I didn't realize you were here. You were hiding.
Yes, I was, Your Honor. Good morning.
Good morning, Mr. Leroy.
Good morning. So on this matter, we'd like to set for preliminary examination as well as dress bond.
Discovery complete?
It is.
People have their witnesses available the 18th. Preliminary examination will be set the August 18, 2026, 9 a.m. before judge. Before me. Esteban.
Your Honor, with regard to bond, Mr. Abuelos has been on a home confinement tether throughout the pendency of this matter. He has not had violations. He has explained to me he's concerned about being unable to work on that tether. Additionally, he has an upcoming family wedding. We'd ask the court to consider removing.
When's the wedding?
That I'm not sure. Mr. Abuelos, can you provide that?
Yes, it's August 18th
In the evening?
in the evening. Yes, Your Honor.
Okay. So what I'll do is I've set the exam for then. I'll deny your request. Don't need a response. I'll deny your request for the tether. I'll address it again on the 18th.
Thank you, Your Honor. We were also requesting a modification of the home confinement tether if it is to remain in place.
Denied. It'll remain in place. Thank you.
Thank you.
Sticker. What? Hold on. Oh, yeah, I had to do that because nobody was here. Okay, whatever. Just, everybody needs to calm down. Court calls case People versus Justin Heaton. What are they doing? Separate those two. It's not Ms. Gaines' fault, so whose it is?
However, on behalf of Mr.
Your name?
Justin Heath,
Thank you, sir.
and I request PR bond, clear in this matter.
Your Honor, may we approach?
Yeah, well, you can. I don't know if you need to, but oh, come on.
Well, all right. Just give a minute.
All right, we're back on the record in the Heaton matter. It's been a bench conference. What I'm gonna do, we're still trying to work on.
Sorry, we'll talk. I'm sorry, Judge. We're asking that the matter be set out 1 week for the reasons we discussed at bench conference.
So I'll adjourn this to the 13th, 2026, 9 a.m. Bond continued.
Thank you, Judge.
Court calls the case People versus Devasier Henning.
Your Honor, Raymond Cook for the people.
David I. Goldstein, attorney on behalf of the defendant. Your Honor, I'm substituting in, but my substitution had the public defender on. When I got here this morning, I found out they are not counsel of record. Mr. Miller is. So I'm gonna have to get the court a different substitution.
Good morning, Your Honor. Jay Grant Miller, P58658 on behalf of Mr. Henning, and brother counsel and I discussed the matter this morning. I couldn't sign the stip for Miss Simpson. So I expect a substitution will be forthcoming.
Mr. Henning, can you state your name, please?
Devasier Henning.
Okay. So how much you're asking to adjourn it?
Yes, Your Honor.
I'll need you green.
I have no discovery. Your Honor, I'm asking for the 27th.
27th. Without objection, probable cause conference will be adjourned August 27th, 2026, 9 a.m. Bond continued.
Thank you.
All right, thank you. Thank you, Mr. Henning.
Thank you. So wait, is Mr. Miller my attorney in this case or?
No, Mr. Goldstein is substituting in. You understand that, sir?
Yeah, thank you.
You're welcome. Court calls the case People versus Sharita AG.
Morning, Your Honor. I'm So Hutchins, Assistant Public Defender on behalf of Charita Aggie, who is standing to my right.
Take your hands out of your pockets. Name?
Charita AG.
Sharif. I missed.
It's okay. You can read it if it's more simple.
What did you say?
You can call me Rita if it's more simple.
Rita? Oh, hey, Rita, what's up?
Hi.
All right. Okay, what are we doing?
Thank you, Your Honor. We are requesting an adjournment for further negotiation.
Probable cause conference will be adjourned September 3rd, 2026, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you. Court calls case People versus Andrew Party.
Next, fellows from people.
Carolyn Foster Tucker on behalf of Andrew Party.
You know, these guys in lockup transport, they do a fantastic job till they're interfered with. Go ahead.
Sorry.
Party. Thank you, sir.
Your Honor, we are requesting a preliminary exam in this matter, and if I may briefly address bond,
Discovery is complete.
to my knowledge.
No other witnesses available the 18th. Preliminary examination will be set August 18th, 2026, 9 a.m. That is before Judge Moore. Esteban.
Your Honor, Mr. Party is asking if the court would consider a release to treatment. I don't believe that there's an objection from the people. If the courts would consider that, I can do a stipulated order.
Objection from the
Looks like there was an MTA in December, but I'm fine. I'll leave it in your discretion.
All right. I will sign an order for release to treatment with, but he'll have to be on a tether.
Okay.
If you prepare the order, I'll sign off on it.
Okay. Thank you.
Right. Thank you. Court calls case People versus Dion Bird.
Assistant Public Defender Zach Vinny with and on behalf of Mr. Bird, who is present via Zoom. Sir, can you please state your name?
Amber.
Go ahead.
Your Honor, we would set this matter for exam.
And discovery is complete.
To our knowledge.
Discovery is complete as it relates to the current charges. Started off as an OWI investigation. We don't yet have the blood back from that OWI, but that would be a misdemeanor that wouldn't necessarily need to be addressed at exam. So we should be able to proceed without that.
All right. Set preliminary examination August 18th, 2026, 9 a.m. before Judge
For you.
for me.
Thank you, Your Honor.
Bond will continue. Thank you. Court calls case People versus Joseph AG.
Ashley Bashir on behalf of Joseph Agee. Mr. Agee is on Zoom. Mr. Agee, if you could say your full name.
My name is Joseph Agee.
Or Agee. Your Honor, we're requesting a brief adjournment for further negotiations on this matter. Sorry.
Preliminary probable cause conference will be
These
August
aren't all.
27, 2020. 9 a.m. Bond continue. Thank you, sir.
Thank you, Judge Simpson.
Court calls case People versus Linnell Wall.
Hey, good morning, Your Honor. Terry Johnson on behalf of Mr. Linnell Wall.
Yep.
Go on to state your name. This is Sharif. Thank you. Just state your name for the Linnell Wall.
All right. All right, what are we doing?
Thank you, Your Honor. We are in receipt of the competency results. I've had an opportunity to speak with my client. We would like to request an independent evaluation.
Okay,
And we have that set up. Obviously, we just need the approval of the court, and I will be submitting an order as well.
but I will allow an independent evaluation that is self-financed. Does that?
Yes, understand, Your Honor. Yes.
All right.
Mr. Johnson did inform me that he had, I believe, an expert already ready to go, just in the court's order.
Oh, correct. So if you prepare an order, I'll sign off on it.
That's fine. Can I submit it to your staff, Your Honor, electronically, or?
Try to get it to me and I'm not gonna sign it. Yeah, you better get it to them. Yeah, just
No problem, Your Honor.
send it to Ms. Weidling. It'll get to me and I'll sign off.
Sounds good, Your Honor.
All right,
And Your Honor, I'm sorry.
go ahead. And how much time then for that to occur? A report, and there's gonna have to be time for the prosecutor to review that report.
45 days? 45 days, Your Honor?
So I'll set a competency hearing. Here's what I'll do. I'll set it for September 17th. If counsel could let me know after receiving that it's gonna go forth, because I'll have to move it to a date that we're clear to hear testimony.
Understand, Your Honor.
Okay. So I'll adjourn this competency hearing date to September 17th, 2026, 9 a.m.
Thank you, Your Honor.
All right,
That's in the middle of football season, or it's the start of football season.
I went to Maryland, so we don't pay attention.
I'm sorry?
Nothing. Yes, it is.
I'm sorry.
It is in the middle. I said I went to Maryland.
No, I heard you say you went to Maryland. That's what I was sorry about, Your Honor. Just. You might be fine, but
Take no, wow. That's outright attack. I was actually being mellow about it. Attack me. Just attack.
that was from Mr. Mikowski, just so the record's clear. So you know who to go after.
I shoot the messenger. I don't have a problem with that. All right.
Thank you.
Thank
you. See you.
Take care. All right. Oh. My little turtle feelings are hurt. Court calls the case. People versus Jamie Alexander.
Here, I'm Jamie Alexander, very sorry.
No, it's okay. Who was over there bothering you? Davi.
No, it was,
Oh, yes, it's his fault.
I
I'm not blaming you. It's Davi's fault. He'll take it.
thank
All right, what are we doing?
apologize, Your Honor. Unfortunately, I have not been able to reach Miss Alexander. She does not have a working phone number and I've requested.
Not in, right?
Yeah.
Bench warrant will issue for defendant failure to appear. Bond will be set in the amount of $10,000 cash surety. That warrant will issue immediately. Here. Court calls the case. People versus Nicholas Coots.
Bangladesh on behalf of Mr. Hood. Can you please state your name for the record?
Nicholas Coots. Thank you, sir.
Your Honor, we have just completed the mitigation process. We did send the packet to the prosecutor yesterday. I believe there is understandably time needed to review that. So I'd ask for a shorter adjournment so that we can resolve this case.
You want the 20th? Will that work? Or you want the 27th? The 20th? Probable cause conference will be adjourned August 20th, 2026, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you. All right. So how many more custodies do this is taking forever?
It was seen for I've got about.
I mean, it's not their fault. Got 15 and you got these. Court does call the case, People versus John Andressen. But I may,
But-
so I mean,
Assistant Public Defender Hannah Apple appearing on behalf of Mr. Andresen. Will you state your name for the record?
John Andreessen, Your Honor.
Andresen.
Where are his pants?
We'll have them next time.
What? Where's,
We'll have them next time.
they're not all here.
It's hot out.
No, really, it's not.
It's like humid. And humid? Humid, yeah. Anne agrees. Judge, I did submit a referral for a request to do some mitigation in this case. So if we could have a little bit longer of an adjournment so I can prepare that information.
Probable cause conference. So I'll have long pants. I'll go into the fall, September 3rd. 2026, 9 a.m. Bond continues.
Thank you.
Thank you, Your Honor. Let's go golfing. Hannah has no idea what to do with that. Court calls the case People versus Mario Crawford.
People.
Do we have the
Offered.
Stephanie Cameron.
Mario Crawford, Your Honor.
Your Honor, we actually, have received, plea paperwork in this case. I'm gonna ask for an adjournment so that the police can.
What?
What?
That was a lot. Was it clear to you?
Was it?
No?
Was I?
No? Was it clear to you?
She wants Crawford, was it clear?
I pretty much think it was.
What?
Your Honor, we have reached a plea deal in this case. I'm asking for an adjournment so that the paperwork can be submitted.
Did you get that, Mr. Crump?
Yes, sir. I did, Your Honor.
You understood it?
Yes, I did.
I had no idea. She could have been talking French to me.
I got no French. I got no French.
What?
We have English under control, Your Honor, so
I know that.
just. So we just need a brief adjournment so we can get a plea.
13.
And
1 week will do.
1 week will do fine, Your Honor. Yes, can I address bond in this case? So my client has been picked up for the tether going below 20%. He had been hospitalized and we have the paperwork showing the hospitalization. He had been hospitalized. I believe I forwarded it to the prosecutor. I did not forward it to the court. I'm sorry. During that process, when he was let out, in his belongings, the charger thing wasn't there. He called his office, his agent, and let them know about it and said he would be coming into community corrections first thing in the morning to charge it. But they came that night and picked him up. So the paperwork, and the agent knew this, that he was in the hospital. They knew this, that they had the conversation. The day he was released, gets home, he can't find the charging cord. He called, told them this, and said, I'll be in first thing in the morning to charge it. And so he was very surprised when the agent picked him up because they had just spoken like 40 minutes before where he explained that he was released from the hospital and the charger was not in his belongings anymore. Your Honor, my client is asking that he be released. Fine with being on tether. He was doing good on tether before he went into the hospital. He's asking to be released on GPS tether again. I think it's yours, right?
Respond.
Only thing that I would add is I do see the defendant failed to appear, I believe, on May 21st, and there was a bench warrant issued on that date. If the court, I recognize we've reached a resolution on this, and part of that was because of the treatment documentation I have received. So I do agree that it looks like the defendant is in a better place than where he was before. Ultimately, I would leave it.
And Your Honor, as to that date, he wound up doing a bench warrant recall. It's my understanding he got the timing wrong. So he called immediately once we communicated, and he was like, I thought it was at this time, not this time. And so he took care of that immediately. Or as quickly as he could based on the circumstances.
Anything else?
No, Your Honor, we just wanted to put that out there.
I'll grant the motion. I will release him. His previous bond is reinstated with the GPS tether.
Thank you, Your Honor. Make sure
Welcome.
here is so.
Oh, don't fist bump. She didn't do anything. I did it.
Thank you, Your Honor. Thank you, Your Honor.
No, I saw that. No, go. Go. Absolutely nothing.
Monday, correct? Or I'm sorry, next Thursday?
Yes.
I just wanted him to hear it and just got excited. I just really liked it. Thank you, Judge. Go Turks.
Court calls the case, People versus Rico Tuso.
Assistant Public Defender Zach Vinu, on behalf of Mr. Artuso and possibly with.
Sure. Leave it alone. But just, what? Why are you coming? Record should reflect we've had a bench conference in this case. I will adjourn this to August 27th, 2029.
Thank you, Your Honor.
You. Pardon? 27. Court calls case People versus Jason Wilson.
And then now we have.
Ready, yours.
Good morning, I'm Rob J. Kill on behalf of Mr. Wilson. Mr. Wilson, would you state your name for the record?
Jason Wilson.
Do we set exams in these matters?
Sure. Discovery is complete.
Yes, Your Honor.
People have their witnesses available the 18th. Set preliminary examination of matters for August 18th, 2020, 9 a.m. before Judge Moore.
Thank you, Your Honor.
Thank you. Bond continued. Court calls the case People versus Faith Askew.
Take advantage of the people, Your Honor.
I'm so Hutchins, Assistant Public Defender for Faith Askew, who I believe is appearing on Zoom. Ms. Askew, please unmute your microphone, show your camera and state your name for the record.
Faith Askew.
Got her. You may. Record should reflect we've had a bench conference in this case. Ms. Askew?
Yes.
I am going to order that you appear in person. I'll need you here at the courthouse later today.
Okay. I'm not sure if I can make it because I don't have transportation. I'm in Detroit.
Hey, so Ms. Askew,
Yes.
I'm going to let you come down here voluntarily. Otherwise, we will send people and solve that transportation problem.
Okay.
So what time can you be here?
I'm not sure, but I don't know. I can figure something out.
Okay, so here's what I'm going to do. You need to be at the courthouse by 2 o'clock. If you're not here by 2 o'clock in that call, I'll be issuing a warrant.
Okay.
Fair enough?
Yeah. Is it
All right.
possible?
Thank you.
Excuse me.
So
Yes, ma'am.
Is it possible if somebody could come get me? Because I'm not sure if I could get transportation.
I don't think you want the people that I'd send to come get you.
Okay, thank you, Judge.
Her mother's present? I got you.
Mother's present.
So I need you here by 2 o'clock.
Okay.
Thank you. Thank you, ma'am.
Have a good day.
Thank you, you too. Court calls the case People versus Fabian Hausner. Who is that?
Good morning, Assistant Public Defender Lauren Perny on behalf of Ms. Hosmer. State your name for the record, please.
Brianne Hosmer.
Thank you.
Your Honor, we're requesting an adjournment. I spoke with Ms. Dover. She just needs a little bit more time for a potential offer. And Ms. Hosmer is requesting a reduction of bond.
Okay, so how much time do you need for the adjournment?
I said just a couple of weeks, Ms. Dover.
The 20th
Sure,
at 9 a.m.
sure.
All right, and then Esteban.
Your Honor, Ms. Hosmer is requesting a personal bond. She stated that at least one or two of her previous failure to appears were because of lack of transportation. If she got out, she does have a stable place to live now with her parents, as well as reliable transportation.
What city is that in?
Manchester.
Manchester.
Her dad could drive her, or a family friend, I believe you said.
Yes.
She also does have stable employment. She cleans houses and does other side jobs. So we're asking for your consideration.
Response from the people.
You see that the defendant has failed for year experience, that would be my concern.
Where were you when you failed to appear? Where were you living then?
I was in Columbia Township. I was in Jackson. Here's what I was gonna ask, Your Honor. They pulled me over. They also pulled up on me the Saturday before Easter and said that they wouldn't bring me out here.
Who?
The Columbia Township Police Department.
So I told her that Your Honor may ask, well, what this
Yeah.
warrant status, what have you been doing? She said that she has been stopped multiple times and they told her they wouldn't take her in for a nonviolent felony. That she interpreted that to mean she shouldn't turn herself in on the warrant because they
said they weren't accepting nonviolent offenders.
Oh, we take all kinds of.
Well, I'm not sure.
That's why you're here. See, that was wrong.
Michigan State Police picked me up.
Pardon?
The state police picked me up and brought me here.
They'll take them too.
Right.
So, and then you're here.
I'm here. Hi.
So Michigan State Police picked you up because why?
From Jackson County.
Jail.
Yes. Unlicensed dogs in Columbia Township. That's 3 years old. Unlicensed dogs, 3 dogs, animal control killed one, so I only have 2, and they're not even in my possession.
That's why you were in Jackson County Jail or Columbia.
Yeah, that's why they picked me up initially. Yeah. Unlicensed dogs in Columbia Township, $1,000 piece.
Okay. So from that, you ended up in jail?
Yes, Your Honor, and Michigan State Police came and picked me up. They said I had a state hold for this. Let me ride in the front. All the way here, whatever.
It was nice of them.
It was very nice.
So you see anything? So she had unlicensed, here's what I get. She had unlicensed dogs. One of the dogs got shot.
The animal control killed one.
Okay.
Yeah.
So one of the dogs isn't with us. She goes to jail. Why'd you go to jail?
I had a warrant for failure to appear for unlicensed dogs in Columbia Township. Like 6 of them. I didn't even know. I had a lawyer. I got picked up on a PPO violation 2 years ago. And they kept me in jail because of the unlicensed dog charge. I had to see a lawyer.
What? Don't try to blame Judge Washington for anything, my good friend. No, Judge Washington does not do that. Other people do that.
So I had a lawyer for the case. I thought the lawyer took care of it. Haven't had the dogs. It's just whatever.
So stay with me here. So why were you dealing with the police at all for them to take you in for the unlicensed dogs?
So my boyfriend, I thought he had my phone. Okay, his mom called the police on me because we were verbally arguing. He was in his shed. I was in my.
Hang it. Go ahead.
I was in the shed, or he was in his shed.
Stop there. So called the police.
Yeah.
Okay.
She
Now
called
I
the
think
police.
that's it. Okay.
Police contact, and she's like, "Oh, I have to take you in on your warrants." But okay, cool. I need a vacation. Well, I didn't think I was going to be here this long, but it's been a vacation. And now I just want to go home. It's ridiculous.
I don't even know.
I'm sorry.
Response.
I did not see any out of county rules currently. So I have not been add towards the agenda.
Why do I get a feeling that if I let you go, it's gonna be a long process to get you back here?
I have court on August 27th in Jackson County. I don't think it'd be a long process.
What?
The dogs.
That the dog thing was over.
It's not over.
They reduced your bond and let you
They let
out.
me out. And I thought I was coming home, and the state police were like, "Oh, Miss Hosmer. Thanks."
So you got. I give up.
Your Honor, I think the biggest difference is now she's in a much more stable situation with her parents.
And I have stable housing. I have a ride.
So you, on the dog, hold on the dog case, you have a PR now.
Yes. August 27th. Oh, they're pit bulls. They're really cute. They're really friendly. You know, it's not even a big deal. Animal control is just harassing me.
I'm out of her bond. I'll grant. I don't know why. I'm gonna grant her my motion. I'll set her bond at a $25,000 personal recognizance bond. Let's make sure you show up.
I'll be here, Your Honor. Thank you so much.
You're welcome.
So I get to go home today?
If you don't have any other holes,
I don't.
go home.
So much.
Huh?
Thank you.
You're more than welcome. All right.
We did.
Hope you enjoyed your vacation.
I did it. I did it. Right. It's been hell. In whole 5 days. It's horrible.
Gotta go home now.
Okay.
All right.
Did we get a PCC date, Your Honor? I might have missed it.
I don't know. That was long before the dogs, and then
Thank you.
20th.
The 20th. Okay, not the 27th.
We
Got
met
it.
here, and then she goes and sees the dogs.
Thank you, Your Honor.
You're welcome, ma'am. You have little faith.
That'd be a long day.
Yeah.
It's a lot, just a lot.
No, that was a lot. And, it's like, tell me what time it is. Don't build the clock. Court calls the case, People versus Warren Abbott.
Brian Bowling, Assistant Public Defender on behalf of Mr. Abbott. Oh, great.
Mr. Abbott, could you state your name?
Yes, Warren Abbott.
Your Honor, I'm asking that this matter be set for an examination, please. All discovery is complete.
People have their witnesses available the 18th. August 18th, 2026, 9 a.m. before me.
Perfect. Thanks, Judge.
Court calls the case, People versus Tony Bailey.
People.
Good morning, Your Honor. Joy Gaines, Senior Assistant Public Defender, with and on behalf of Mr. Bailey.
Name, sir? Tony. How you doing? Good morning, Tony Warren Bailey. Thank you. All right, what are we doing?
Your Honor, we are requesting a preliminary examination at Tether.
Discovery is complete.
That is my understanding.
People have their witnesses available the 18th.
Your best, Your Honor.
Preliminary examination, August 18th, 2026, 9 a.m. before Judge Moore.
Thank you, Your Honor.
All right, bond last day saying. This is?
Yes.
Yeah, you know, you're right, because you'll be before Judge Moore.
You ever look me up on YouTube yet?
Have I looked you up?
Remember, he's a musician.
Yes. I haven't. I try to stay off of YouTube. It doesn't work well.
Go on there.
Oh, I do know. All right. Thank you.
Have a nice one, okay?
Take care, Mr. Bailey. Court calls the case of the people versus Zachariah Haruska Dennis. What did you?
Kerma Jadush on behalf of Mr. Dennis. Can you please say your name for the record? Can you please say your name for the record?
Dennis, Your Honor.
All right, he's waiving on all of this.
Yes, Your Honor. He is waiving his right to preliminary examination. Sorry, yeah.
All right. Sir, you're waiving your right to a preliminary examination?
Your Honor.
You understand that that's a proceeding where the people would have to show by probable cause if the offenses alleged were committed, that you committed. You understand you'll not have that hearing and you'll proceed to circuit court for further resolution.
Yes, Your Honor.
People also waive their right?
Yeah.
Preliminary examination having been waived. Defendant is bound over to circuit court on all three counts in the two cases.
Honor, we do a formal reading of the complaint and stand mute.
Defendant having waived formal reading, standing mute to all charges, court will enter a not guilty plea. Pretrial will be set for August 17th, 2026, 1:30, Judge Hammoud. Bond will continue.
May I purchase any information, Your Honor?
Yes, momentarily.
Thanks, Your Honor.
Yeah, I did the ones. It's just not. Court calls the case, people versus Alexis Baker.
Morning, Your Honor. Raymond Cook for the people.
Your Honor, Mr. Hutchins, Assistant Public Defender, on behalf of Alexis Baker. Alexis, please state your name for the record. Alexis Baker. Your Honor, we are setting this for preliminary exam.
Discovery is complete.
To the best of my knowledge, yes.
We'll have their witnesses available the 18th.
Do our best, Your Honor.
Preliminary examination will be set August 18th, 2026, 9 a.m. before me.
All right.
Bond will continue. Thank you. Court calls case, people versus Orby Huffman.
Brian Bowling on behalf of Mr. Huffman. Please, Mr. Huffman.
Orby Huffman.
Okay. That says 1 and 2. Yeah, it's just one. Okay. Yes.
Hey, Judge, it's come to my, that Mr. Huffman has a case pending before Judge Conlon. And he was referred for a competency evaluation in that case. I believe that happened July 16th. Based on that referral in that matter, I think we need to adjourn this case to wait the.
We can adjourn it. Did you want to do a new referral also on this case?
Yeah, I mean, I guess, yeah, if that's.
I think we should probably do that.
Fair enough.
All right, so why don't I just put it out 2 weeks and that way you can get the paper, you can get it here. I'll call it up at that point. We'll do the referral.
Fair enough.
They'll match it up.
Okay, thanks, Judge.
So I'll adjourn this to August 18th, 2020. No, that was wrong.
20th.
August 20th. 2026, 9 a.m.
And that will be for a probable cause conference. That's what.
Yes, or can I'm setting it for.
I'll get the court in order shortly.
Right.
Thanks, Judge.
Mr. Baker, you hand those to the Skinner to sign up. Court does call the case people versus William Baker.
Assistant Public Defender Emzo Hutchins on behalf of William Baker. Mr. Baker, please state your name for the record.
Baker. Thank you.
Your Honor, we are requesting an adjournment for further negotiations and assessments.
Okay. You're asking for an adjournment on this, right?
That's correct.
Okay, I'll adjourn it to August 27th, 2026. 9. There's also been a request regarding a bond modification. I won't put the last name on. I will allow, I will delete the contact, no contact with Jillian. I'll just do it straight that way.
Thank
you. Okay, thank you.
Oh, Your Honor, I'm sorry. What was the next court date?
27. 27.
August 27th. Thank you.
Court calls case people versus Scott Matthews. What is David's do?
Scott Matthews, let's see.
Scott Matthews. Scott Matthews.
Good morning, Assistant Public Defender Lauren Perny on behalf of Mr. Matthews. State your name for the record, please.
Scott David Matthews. Thank you.
You know, Mr. Matthews has cases in 15th District as well. We're seeking an adjournment to see if we can do a global.
What's his next date on the 15th?
Do you remember, Mr. Matthews?
I do not.
Maybe it's the 26th.
I can adjourn it out to the last date I have this month. And
Maybe we do the 20th, and if something happens here, that will help 15th too. Does that make sense?
That's the optimist.
No, that is true. That, yeah, maybe do a fall.
The 20th. You
Okay,
okay? I'll adjourn these PCCs to the 20th.
okay,
Okay.
thanks.
Hey, you're welcome.
I'll be in.
Court calls the case B versus Angela Ball. What is Bellinger doing? He's had one case.
Asli Bashir on behalf of Angela Ball.
Her name?
Angela Ball.
Thank you.
And Your Honor, we are requesting an adjournment. An offer has been extended, although we are asking for just a 2-week adjournment for further negotiation.
August 27th, 2026, 9 a.m.
I'm sorry,
27th?
the 27th?
Yes, ma'am.
Okay, thank you.
All right, you're welcome.
Okay.
Court calls case People versus Kendrick McBride.
Assistant Public Defender Davey Lieb on behalf of Mr. McBride.
Sir, keep moving up here.
How you doing?
What's your name?
Kendrick Brown McBride.
Thank you.
And I would like to set this matter for preliminary examination. Discovery is complete.
People have their witnesses available the 18th. Preliminary examination, August 18th, 2026, 9 a.m. Yes,
Now, I had went to the emergency room.
pardon?
I went to the emergency room a couple days ago. The doctor said I'm allergic to mold and soy. It's inside the jail, and I'm breaking out every day. And I need help to get this stuff out of my system.
Okay,
See all of this?
so what are you asking for me?
Is there any way that I can get treatment while I'm in custody? Because this is happening every single day. I'm just breaking out all over my body.
Have you asked the folks at the jail, medical at the jail?
Yep, I've been asked.
What did they say?
They just keep giving me third tech and stuff that's not working. Like, I need to get.
Okay, you have to tell them, I'm not a medical person, so I can't
Yeah, it's
tell you. Certainly the public defender's office can make sure that there's communication to the jail regarding your treatment, okay?
And I can reach out to the medical staff.
All right, very good.
Thank you.
For the
Judge Moore.
And Your Honor, my apologies. Was that the 18th?
Yes.
Thank you. Thank you very much.
But he was just Bellinger. I was just saying, what? I just don't know what he's doing now. Davi, what's Bellinger doing? He's had only one case.
Just move on line up and I'll.
Okay, all right.
I will.
I don't know. You sitting at the first seat, you make me nervous. All day I've been nervous. Court calls the case, People versus Anthony Bart.
You're on ready to go to the people.
Senior Assistant Public Defender representing Mr. Barton. On Zoom, I know he was having some difficulty earlier. He had
Mr. Barton? If that's you, Mr. Barton, I can't hear a thing you're saying. You need to unmute.
So where the microphone is, Mr. Barton, that is him. Where the microphone.
That is Mr. Barton?
Yes, I'm
Say that in.
receiving a Teams message from, like I said, he was having trouble. I'm receiving a Teams message.
All right.
Paralegal.
Mr. Barton, hold on a moment. Just don't panic. You're good. All right. Wave your hand if you're Mr. Barton. Where are you driving to? Don't drive. You need to be parked. Oh, he's moving. Yeah,
So, I think he's saying he's not driving. He's showing.
saying you're not driving.
He's showing.
Okay, good. Okay. It's not driving. I got finally.
So
I'm not driving.
he's not driving.
Hold it. Say something again.
I'm here. Can you hear me?
Okay, yeah. Now I hear him. All right.
Okay.
Yay.
Whoa, this has been heck trying to get on here. I've been here 2 hours and something. Trying to get on here all morning. Can't talk to nobody.
Okay. Okay.
All right, what are we doing?
Your Honor, we have two things. First, we are requesting an adjournment for ongoing discussions and for discovery. And the second is we'd like to address Mr. Barton's bond. The conditions of his bond. Mr. Barton is a truck driver, which is why you see him in his truck today. He
See in a truck? It looks like a car.
well,
You in a truck
Yeah,
or a
I'm in
car?
a truck. I'm in a truck.
You are? That's a
Yes.
short truck. Go ahead.
okay.
No, I'm just seeing stuff out the side.
It's a
No,
day
go-
cab.
Never mind. Go ahead.
Truck driver.
Okay.
And he is concerned because he also is required to test weekly with community corrections. And so, for example, he was asked to test Monday, and for his job, he was in Chicago on Monday and Tuesday driving. So we are asking, and
We'd let him go out of state for his work.
that is my understanding.
Let's hope so.
Yes.
All right, go ahead.
So with that, we are asking if and just one more thing, Your Honor, he is required, he is not permitted, to use drugs or alcohol because of his job in particular.
Right, because it's a truck driver. I get it.
Yes. So we are asking that the condition that he be required to test deleted from his
How long is he
requirement.
testing?
Not long, Your Honor. I believe he was just arraigned maybe 2 weeks.
4 times.
You've tested 4 times?
Correct.
They've all
And I've
come
been
back
negative
clean.
all of them.
Yeah, I got you.
I I wouldn't have an objection to removing the testing. I remember when this case was arraigned, I think the reason for the request for testing was just out of concern and safety, because this could have been mental health or substance abuse related. We weren't.
Got it.
Just to make sure, if he's been testing clean, I think that shows us more of a mental health rather than drug or related issue.
Understood. Okay, then I will delete that provision. I'll grant your request for bond modification. I'll delete the testing.
Thank you, Your Honor.
All right, did we give a date already? So then you want this adjourned?
Yes, please.
I'll
Your Honor,
adjourn
can I
it.
speak for one moment?
Sure, everything's going your way, so you'll probably blow it, but go ahead.
Well, no, I'm not saying nothing crazy.
No,
so-
go
so-
ahead. What do you want to say, sir?
Please.
In this case, so what's happening is the people
So,
that
so I
this
think,
whole situation happened with.
Hold on, whoa, I gotta stop you.
Okay.
I don't want you talking about your case at all.
Oh, no, I was just talking about where they reside. They live 6 doors down from me.
that's okay. That's okay, Mr. Barton. Are you?
Your
Okay,
attorney's
I'm
telling
sorry.
you stop.
Okay, all right, I know nothing. My name's Ben.
There
I
you
ain't in
go.
it.
Okay, there you go. Very good.
Okay.
Okay, so I'll set this for September 3rd, 2026, 9 a.m.
Thank you.
All right?
Thank you, Your Honor.
And I've signed an order deleting that condition already.
Thank
All right, thank you, sir.
Thank you. You
Stay
have a
safe
blessed
out
day.
there.
Yes, sir. Yes, sir. Have a good one. Bye.
You too.
Court calls the case, People versus David Phelan.
Phelan. I thought you said Phelan. Not that I know that there's one on the record or anything, so. Hi.
He woke you up from your nap.
Oh, come on. Mr. Phelan, can you please state your name for the record?
David Phelan.
And Assistant Public Defender Jay Bellinger on behalf of Mr. Phelan.
All right,
Your Honor, we are waiving. There is an offer that Mr. Kennedy would like to put on the record for us.
And then counsel, I agree that the bond buying over to each can add account 4, innovation second, that's back for 7 by 1. So we have worth $3,000 and add account 5 of criminal sexual conduct of the fourth. The back code 750.520 E1A, max penalty 2 year and or $500. We have not reached a sentencing agreement, but plan to do so once we're in source for them.
That's our correct understanding of the offer, Your Honor.
So you're waiving your right to a preliminary examination?
Yes,
You understand that that's a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
yes,
You understand you will not have that hearing. You'll proceed to circuit court for further resolution.
yeah,
You understand that?
yes,
Okay. People also waive their right. Preliminary examination having been waived, defendant is bound over to circuit court on all 3 counts.
Thank you, Your Honor. We waive formal reading stand mute at this time. I acknowledge receipt of information.
Defendant having waived formal reading, standing mute, court will let her not guilty plea. Pretrial will be set for
August 25th at 1:30 with Judge Conklin.
August 25th, 2026, 1:30.
Thank you, Your Honor.
Bond will continue. Thank you.
I'll be in touch with you, okay?
Okay, we're good. Get him signed. Court calls case People versus Stephen Wainwright.
You got court, Wainwright. Assistant Public Defender Davi Lipa for Mr. Wainwright.
Wait.
Mr. Wainwright,
Mr. Wainwright. Mr. Wainwright, you got court.
Mr.
all right, that's,
Wainwright.
it's okay. Officer, you're at his cell, however, correct?
Yes, sir.
All right, thank you. What are we doing?
I'm requesting an adjournment. We do have an independent competency evaluation progress. Our office just received the retainer agreement yesterday for our expert.
For your expert,
Yes.
and how much time are you gonna need?
That I don't know. I would ask for 30 days at this point.
All right.
Thank you.
I'll adjourn these out then to September 3rd, 2026, 9 a.m.
Thank you.
Bond will continue. All right. Pardon? The third. All right, thank you. Thank you, officer. Court does call the case of the people versus Shantia Bonner.
Judge, she just stepped out to use the restroom.
Let's arrest her. No, I'm kidding. I'll pass. Hey, ma'am, tell her she doesn't have to run. Yeah, I'll pass it. All right. She kind of just took off. Court calls the case people versus Francisco Quezada Loretta, actually.
On behalf of Mr. Quezada Francisco.
And with your name. I can really.
Update your for the
first name.
Francisco Andres Quesada Loretta.
What he shared. We're asking for an adjournment. I like how he pronounced it. It didn't sound.
What?
How he said his name. It didn't sound like it when I said it.
No, it did not.
Oh. We're asking for an adjournment, Your Honor. We want to find out some information on an out-of-county matter.
How much time would you need?
Uh,
I can do the 20th, 27th, 3rd.
let's do the 3rd.
3rd.
Judge.
Adjourn it to September 3rd, 2026, 9 a.m. Bond continue.
Thank you, Judge.
Thank you, sir. Court calls the case of the people versus Garcia Bravo.
Assistant Public Defender Happy Liba from Ms. Bravo Garcia.
Bravo. State your name, please.
Jacqueline Bravo Garcia.
All right. I have before me a plea form. In this case, she's going to plead guilty to the charge of failure to return rental property.
Correct, Your Honor. The
1-year offense. Upon her successful plea to that charge, count 1 would be dismissed. Defendant agrees to pay restitution in the amount of $4,879.33. That's the court's full understanding of the agreement.
It is correct, Your Honor.
Please raise your right hand to be sworn. Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
All right. State your name again for the record, please.
Jacqueline Bravo Garcia.
All right. You can put your hand.
Okay.
It is this court's understanding that you are going to be pleading guilty to the charge of the offense of failure to return rental property. That is a misdemeanor punishable by up to 1 year incarceration, a $2,000 fine plus court costs. The fine could be increased if 3 times the value of the property. If that's greater than $2,000, that would become the maximum fine. Do you understand that?
Yes, Your Honor.
All right. You also understand that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Washington in the 14B District Court. You understand that?
Yes.
All right. Still wish to plead guilty?
Yes, Your Honor.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes.
Did you sign or have cause to be signed an advice of rights form on your behalf?
Yes.
Any questions regarding any of those rights?
No.
Please look at paragraph 5 on that form. You understand you're waiving those rights as well as all the rights on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
Probation.
Were you on probation at the time of this offense?
No.
Has anybody promised you anything other than what's been stated here today to get you to plea?
No,
Anybody threaten you or coerce you?
no,
You're doing this voluntarily and of your own free will?
yes, Your Honor.
And also because you believe that you are indeed guilty of this offense?
Yes, Your Honor.
October 6, 2024, at the location of 2714 Washington Avenue in Ypsilanti Township, Washington County, State of Michigan. Did you rent from a U-Haul there?
Yes, Your Honor.
And was it rented was it 2012 Ford Ecoline 20-footer?
Yes,
All right. And there was a point where you were to return that, is that correct?
correct.
And did you fail to return that property?
Yes, Your Honor.
And did they make a demand for the return of that and you still did not return it?
Correct.
Ma'am, I do have to advise you that if between the time I accept your plea and the time of sentencing, if you commit misconduct as defined under the Michigan court rules, you would not be entitled to withdraw your plea and the judge would not be bound by any sentence evaluation or recommendation. You understand that?
Yes, Your Honor.
Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
And have I complied with the court rule?
You have, Your Honor.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14B. Probation sentencing will be September 10th, 2026, 10 a.m. for Judge Washington. Bond will continue.
Thank you, Your Honor.
Thank you.
Thank you, Your Honor.
Thank you. Court calls the case People versus Ronald Ray Wilson. 3 cases.
That is a number, Your Honor.
Sure, me, senior assistant public defender. Ray Wilson.
Mr. Wilson, can you state your name, please?
Wilson.
Thank you. What are we doing?
Your Honor, Ms. Cinda has informed us that there has been some additional investigation and that they intend to add some additional charges. That there is a supplemental report forthcoming from that additional investigation. I've informed my client that we are expecting that should be happening soon, and that in addition, we have been told that there are definitively 4 more warrants that are have been requested and are in the process of being charged. With that information, specifically for the 1 case where there will be the additional charges, Mr. Wilson is aware that it is my belief where they're going to, or my advice that we have that additional discovery because they can add charges at the preliminary exam, and I would like to see that, or whomever from our office will be representing him would like to have that information and be able to prepare for an exam accordingly. After much discussion, Mr. Wilson is stating that he would prefer to have the preliminary exam set and to exercise his right and to make that request over counsel's account.
So which case is that?
That is the
Case in 073 Marvel, no report that describes those potential charges and potential CSC related charges. There are other warrants in the queue that are being reviewed. I believe 2 are. One is malicious destruction of personal property, and I believe 1 involves an incident in the jail where Mr. Ray Wilson is accused of throwing his feces on correction officers in their face, along with potentially having shake. Those are under review as well. So I do not have those currently charged. And there's further interview that needs to be done with them on that 0784 case regarding the potential CSC allegations of verifying her medical records. I think those should be here within 5 years.
So he wants his exam on 0784.
He wants his exam on all three matters, Your Honor. And I have specifically said that I think that we should definitively at least wait on that matter. But given that there are all of these cases, that there may be some benefit to trying to resolve these together as opposed to having them come slowly through the system and keep adding up.
So, so sir, you want your exam on these matters?
I just asked to move forward, not to studying not to extend it for today. I was just asking, so what's the next one is the set for preliminary exam, right?
Well, that would be the next stage, but you got all this other stuff out there. That's what your attorney's indicating. And she'd like to take a look at it, but if you want them set for exam.
I mean, they ain't rearranged me on no other cases yet, so this is the only cases that have been rearranged on. So
Yeah,
I mean, go off of this wish.
The other ones are about to be charged.
Well, I haven't seen the paperwork, but I have not been rearranged on them yet, so.
Okay. So you want exams on these?
Yeah, that's what the next one is set for, right? And we moving forward for the next case, and that's the next one for after this one, right?
Well, that would be the next stage, but your attorney's advising you not to necessarily take that step right now because of these other things that are out there.
I mean, I have not been rearranged on there, Your Honor. So I mean, I don't see.
I know you want to be rearranged. Okay, so here we go. I'll just set him for a preliminary examination. We'll just let it fall where it may. He will not be entitled to an adjournment if there's something there that relates to the case, so.
I will note, Your Honor, he's also a mandatory minimum habitual court offender as well.
He's say
Mandatory minimum habitual.
25-year mandatory minimum. All right, well, he wants to handle it that way. He doesn't want to listen to his attorney. Set preliminary, would the people have their witnesses available the 18th? Set preliminary examination, August 18th, 2026, 9 a.m. before for me. Call me lucky. All right.
Your Honor, if I may approach with Ms. Senta briefly.
Yes, you may. Court does call the case, People versus Stephen Lee Schumacher.
And then on behalf of the people, Your Honor.
Oh.
Assistant Public Defender Daffy Lebo for Mr. Schumacher.
Your name, sir?
Schumacher.
Thank you.
And a relaxed assessment for preliminary examination, please. Discovery is complete.
Do I have their witnesses available the 18th?
Yes, Your Honor.
Preliminary examination will be set August 18th, 2026, 9 a.m. for Judge Moore.
Thank you.
What? Why you, what? What? So you're raising your hand? All my cases are in a line. I called your case. Then next thing you know, she got up running. And then I was going to issue a bench warrant. But then people told me you were coming back. And now you're raising your hand to serve in the court. I could have called 8 cases by now. I'll call you in a minute. You're welcome. Oh boy. I don't know why people are rushing for me to call the case. Court calls the case, People versus Brian Trent.
David I. Goldstein appearing on behalf of the defendant.
Your name, sir? Brian Trent.
Your Honor, I was just retained in this matter this week. I don't have discovery yet, so.
All right.
Can we have September 3rd?
Probable cause conference will be adjourned to September 3rd, 2026, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you. Thank you, Your Honor. Thank you, sir. Nope. Court calls case, People versus Natasha Brazelton. I'm gonna make you wait. I had to wait for you to come back.
Council Perry, I can rule your honor on behalf of Ms. Hazelton,
Oh, docket flow, she's not going to appear.
I can't talk any slower, Judge. Unfortunately, Your Honor, I have not been able to make contact with Mr. Hazelton. We called and left messages to no avail. I do not have an explanation for her absence today.
Bench warrant will issue for defendant's failure to appear. Bond set in the amount of $10,000 cash surety.
Thank you, Judge.
Nope. Court calls the case versus Laura Walter.
Good morning, this is Smoke Expander Lauren Perny on behalf of Ms. Waldron. Ms. Waldron, state your name for the record, please.
Laura Waldron?
Your Honor, I have two requests. One is that
Why can't you have one? Go ahead.
I don't know. One is an adjournment. So Ms. Waldron completed some treatment while this case was in warrant status, and I am trying to get proof of that to Ms. Phelps.
Gotcha.
My second request is a release of treatment. I did speak to Ms. Phelps about this. She has some hesitancy due to that warrant status. I suppose I'm now coming to the court for your consideration if that's a possibility. The controlled substance case, I think Ms. Waldron did complete some time at Odyssey House in Saginaw. She is working with, she does have a case manager with DHHS who wants to see her do additional treatment. So she is asking for a release to treatment on this case.
This case is originally in 2023, got authorized in 2024. The defendant unfortunately failed to appear in November of 2024, was offered on Toledo, and she was rearranged in November of 2025. After being arraigned in November of 2025, on December 23rd, she had failed to appear, came late, bench warrant was recalled on that date, and then again failed to appear on January the 15th, 2026. She was here, she let me do with the bids, and then got a ride to get, then had a flat tire, some sort of difficulty there. She was arraigned and said that she had done the treatment. My concern is that we've had 2 failures to appear, she's gone for a year, and I'm just concerned with.
How'd she come back into custody?
She called the police due to a domestic situation. The warrant was pending.
And I think she may have been the victim in that situation. I'm sympathetic to that, but still have.
We still, right. How long an adjournment did you want?
I think Odyssey House said their records person was out yesterday. I think we can get those pretty quickly. I think Ms. Feltis and I are of the similar mind on the resolution of the case, so I have no problem with the 20th. Yeah,
I'll adjourn it out to August 20th, 2026, 9 a.m. I'm going to deny the request for release. Circumstance.
I may file a written bond motion.
I'll read it.
Great. All right, you read.
Then great. Then we can all get together and I can deny it again. No, go ahead.
So just to put y'all on notice, I'm working on some.
That was really country, y'all on notice. Go ahead.
Yeah.
Okay.
I'm not country at all. I don't know.
I know you're not. I don't know where that y'all came from. So that's fine. I mean, if you want to file a written motion, maybe then.
I think there's additional context that the court.
Right, and I may, some of that may come from the records and things you're waiting for. That
Exactly.
I would need to.
Yeah.
Okay, so I certainly will take another look at it. I don't know. Okay.
All right, thanks.
So at this time, we're about, we'll continue. Court calls the case People versus Michael Brown.
As adults with equal.
Oh, I was gonna call her. No, I wasn't.
Assistant Public Defender Davy Leba for Mr. Brown.
Michael Brown.
Thank you.
And Your Honor, provided Ms. Felt with some mitigation information, she's going to be reviewing and be requesting an adjournment for that to happen.
Turn it to August 27th, 2026, 9 a.m.
Thank you, Your Honor.
Thank you, Your Honor.
Bond continued. Court recalls the case. People versus Shantia Bonner.
Morning again, Your Honor. Raymond Cook with people.
This is a recall. Because the first time I called it, she wasn't here.
That's correct.
That's why I'm recalling.
Good afternoon, Judge.
Good afternoon. What's your name?
Santia Bonner.
We knew that. Okay.
Assistant Public Defender Hannah Apple appearing on behalf of Ms. Bonner. Your Honor, we have some missing video discovery. I did reach out to APA Cook. Get that information for us, so we asked for an adjournment for that purpose.
And that's the request that I'm hoping I can get in the next few days.
Okay. Who's that with you?
My mother.
Your mother?
Mhm.
She's fast.
Is she?
When I called that case, by the time I got your name out, she's out of that aisle, flying out the door. Bless her heart.
That's my mama.
Yep. Okay. I'll adjourn this then to, why don't I give you till September 3rd, 2026, 9 a.m.
Thank you.
All right.
Judge.
Fine, continue. Not a problem. Mom, take care. Court calls case versus Melvin Witherspoon.
Assistant Schneider, Your Honor, on behalf of Mr. Melvin Witherspoon, who's approaching. Mr. Witherspoon, state your name for the record.
Melvin Witherspoon. Yes, sir.
We ask that this matter be set for preliminary exam, Judge.
Discovery is complete.
To our knowledge, it is.
Other witnesses available the 18th. Preliminary examination will be set August 18th, 2026, 9 a.m. before me.
Thank you, Judge.
Bond continued. Tommy, where are you going?
You're welcome.
Oh, okay. See ya. I do that. I know he hates to hear my voice. What was that? Bellinger. Stop. Just stop. You know what? Taking somebody in today.
I need a vacation.
Volunteer.
I know, right? Thank you for staying at our hotel. Court calls case people versus Ashley Burke.
It's Brick, that's why.
Brick? Well, okay. It
It's
was
Bert,
close.
good morning.
Hey, it's okay, ma'am. Hold on. I gotta yell at your attorney.
Yeah.
That was your fault. You knew what I was calling.
I didn't.
Didn't?
No.
Should have paid attention.
I
Everybody else knew.
understood.
Ma'am, what's your name?
Ashley Burke.
Thank
Morning.
you. Good morning. All right, I have before me a plea form. Is that what we're doing?
That is my understanding, Your Honor.
Form indicates that she's going to plead to use of methamphetamine for 1 year offense. Upon her successful guilty plea to that charge, count 1 would be dismissed. That's the court's full understanding of the agreement.
Yes, Your Honor.
That is our understanding as well.
Ms. Burke, if you please raise your right hand to be sworn. Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
All right. State your name again for the record, please.
Ashley Burke.
All right. You can put your hand down. Ma'am, it is this court's
Okay.
understanding that you are going to be pleading guilty to the charge of use of a controlled substance. That's a misdemeanor, punishable by up to 1 year incarceration and a $2,000 fine plus court costs. Do you understand that?
Yes, I do.
And understanding that, do you still wish to plead guilty?
Yes.
And to that charge, how do you plead?
Guilty.
You understand that by pleading guilty, you'll not have a trial of any kind.
Yes.
You signed an advice of rights form, is that correct?
Yes, it is.
Any question regarding any of those rights?
No.
Looking at paragraph 5, you understand that you're giving up those rights as well as all rights on that form.
Yes.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
I am on probation.
Okay, at the time of this offense, were you on probation?
No.
Has anybody promised you anything other than what's been stated here today to get you to plea?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily and of your own free will?
I am.
And also because you believe that you're guilty of this offense, ma'am?
Absolutely, yes.
On the date of June 29, 2023, at the location of 3200 Carpenter Road, Pittsfield Township, Washington County, State of Michigan, did you have methamphetamine or ecstasy in your possession?
I did. I did.
And had you used it?
I was.
And did you know what you were using was methamphetamine or ecstasy?
Yes.
Ma'am, I do have to advise you that if between the time I accept your plea and the time of sentencing, if you commit misconduct as defined under the Michigan court rules, you would not be entitled to withdraw your plea and the court would not be bound by any sentence recommendation or evaluation. You understand that?
Yes, I just I don't want to interrupt, Your Honor. I don't know if my public defender, if he know, I've been in treatment. I'm a year and a half clean now from methamphetamines, and I'm still in treatment. I'm in recovery housing. I've been in recovery housing for a year now. I'm actually doing pretty good. So I just wanted to state that, Your Honor.
Okay, I remember that from the last time you were before me.
Yeah.
Okay.
Your Honor, I was going to discuss that with the court with regard to the sentencing itself, because I think that she could potentially have a problem getting down to probation over here, since she is still in treatment, but.
Yeah, but we'll, all right.
Cross that bridge.
Okay, where was I? You said they weren't going to interrupt, but they did. I didn't even do that. Okay, see, this is what happened. Counsel, are you aware of any other promises, threats, or other inducements which had led to this plea?
No, Your Honor.
Have I complied with the court?
Satisfied, Your Honor.
There we go. Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14A1 probation. Sentencing in this matter will be September 9th, 2026, 9 a.m. before me. Bond will continue. What we will do, ma'am, is contact our probation department, much like you're appearing here via Zoom. I'm sure they can do your interview and assessment that way.
Okay.
Okay.
I just have I just have one question, Your Honor. Am I able to have like my probation, if I do get probation, can it run concurrent with my Oakland County case? Because I'm still got a whole year with them. Like I'm on probation for 2 years with them.
Well, here's what'll happen. I'm gonna let my probation officer take a look at that. She'll know. And typically, so that you just understand, you'd have probation here. We're not going to try to duplicate anything that you're already doing. All right.
Okay.
But I'll let them take a close look at that. Okay.
Okay. Yeah.
All right. Thank you, ma'am.
Okay. Thank you, Your Honor. Oh, yeah. September 9th. You guys have a blessed day. Thank you.
Oh, you're welcome. Court calls the case, People versus Jasmine Yates.
Send on behalf of people, Your Honor.
Assistant Public Defender Hannah Apple appearing on behalf of Miss Yates. Portion now, Miss Yates, will you state your name for the record?
Jasmine Yates.
Your Honor, we're asking that this matter be set for preliminary examination.
Everybody, well, discovery is complete.
To our knowledge, yes, Judge.
People have their witnesses available the 18th. Preliminary examination, August 18th, 2026, 9 a.m. before Judge Moore. Bond continue.
Thank you.
Thank you. Court calls.
Your Honor.
First, you're welcome. Court calls case People versus Gregory Mason.
Convention of the Fair can rule, Your Honor, on behalf of Mr. Gregory May on zone check.
You got court. You got court. Mr. Mason.
Mr. Mason. All right, officer, that's Mr. Mason's cell?
Yes, sir.
All right, you're requesting a forensic evaluation?
I am.
I will order a forensic evaluation. I'll set a competency hearing for November 5th, 2026, 9 a.m.
Thank you, Judge.
Bond will continue. Thank you.
Is there?
Thank you, sir. Court calls case People versus Kenneth Bunt.
Morning, Your Honor. Good afternoon, now, Your Honor. Cook to the people.
Good morning, Your Honor. Ashley Hannibal requesting permission to practice pursuant to Michigan Court Rule 8.120 under the supervision of Stephanie Cannon.
Permission to practice is granted.
All right. On behalf of Mr. Bunch. Can you, your name?
Paul. Okay. All right. Requesting.
Yes, Your Honor.
All right. I will adjourn the matter. I'll adjourn it to the 20th. However, we have a bond violation for. Are you aware?
I was not, no.
Well. July 20th. A positive alcohol test. And then a series where he did not retest.
Sorry, Your Honor, Stephanie Cannon on behalf of Mr.
Bunch.
Bunch. Your Honor, I was unaware of those allegations. My client, of course.
July 20th, 2026 at 6 a.m. Mr. Bunch submitted a positive test with a blood alcohol content of 0.035. On that same date, at 6:23 a.m., he submitted another positive test, 0.034. And 7:14, I'm sorry, 6:47 a.m. blood alcohol content of 0.032, and at 7:14 that same blood alcohol content of 0.024. On that same date, as pursuant to what the program that he's in the testing, he was to submit to scheduled retest. He failed to do so on that same date at 7:29, 7:59, and 8:29. Did not retest.
Have you been testing since then?
Yeah, it didn't tell me to read it.
Thank you, Your Honor. My client is aware of the allegations against him. Are we arraigning him on this, Your Honor, at the moment, or just letting me know what's happening?
Well, he happened to show up before there was a warrant that was signed.
Okay.
So it was going to be a no bond warrant, but.
Thank you, Your Honor. I've spoken to my client regarding, he's heard that, he's been talking to me. It's my understanding that since then, he has not been testing positive. He is going to AA, he has a sponsor. He's not going to tell the court that he has not or had not struggled with his sobriety up until then. But as a result, he has taken every step he can possibly take to remain sober. He has his AA paperwork with him today.
He admitting to these? Or not?
The 721.
Because here's what he told Community Corrections. They contacted him on that same date. He denied consuming alcohol.
Your Honor.
And then stated it must have been his mouthwash.
Your Honor,
I haven't heard that one in a minute.
Yeah.
But yeah, because that takes a pretty powerful mouthwash to last that long.
In talking to my client, that is not what he told me when he talked to me about it. He was very truthful
Okay.
and forthcoming, and he's not going to tell the court anything different than what he told me regarding that particular incident, that situation. As a direct result of that, though, he did take every step possible that he could take to make a sobriety. He started going to AA. He started working with a counselor. He's been doing everything he could as it relates to that, Your Honor. So he is. Are you going to admit to that drinking incident? You need to be truthful. Did you drink?
Believe I did, actually.
Yes, Your Honor. He is admitting that. He's admitting
That what?
that he had a mixed drink on that day.
Why didn't you just tell community corrections center?
Your Honor, I believe my client wanted the opportunity to just go and take care of it. He started doing everything he could. Like I told you, he has proof of AA. He has proof of him taking care of his sobriety. I think in that moment, he just he didn't want to have to go back to jail. He wanted to put steps in place so that he perhaps didn't have to go to jail as a result of that violation.
I didn't have any intention of drinking. I didn't realize there was alcohol in the house. I woke up in the middle of the night, I drank something, you couldn't undrink it.
You realize there was alcohol where?
In my house. Anyway.
Your Honor, he just, when he spoke to me about it, he said he made a very bad mistake. He understood his mistake. He's been trying to fix that day. So he is going to admit that he did have a drink that day.
What's he been doing since the 20th to try to resolve it?
Yes, his AA paperwork. Yes,
Wasn't he at that before?
Were you attending AA before?
Yes.
He has his AA paperwork.
So what's he done different, given this event?
Oh yeah. He's been working with his sobriety coach intently, Your Honor. He tells me that since that incident, he has not had anything to drink. It indicated that it really was almost reflex because he has been drinking for that long. He admits that it was almost like just a reflex, and once it happened, he knew he couldn't fix it, so he called his sponsor. He's been working as best he can to maintain his sobriety since that incident.
Mr. Cook.
People are going to be asking for remand with potential consideration of release to treatment down the line. But I have some suggestions for this defendant, and that it seems to me he has an alcohol problem, and that problem is winning. And I don't think that if he's released, he can on his own get the treatment needed to help him work off of this. My concerns arise both from the history of this defendant, the underlying facts or allegations of this case, as well as some statements that have been made. Specifically as it relates to the defense prior history, he has a prior operating while intoxicated second, as well as allowing an intoxicated individual to drive. In this case, the report indicates he was a .377 when he punched an officer in the face. And then I also have concerns because looking at the notes from arraignment, it indicates our office had initially requested a scram tether. The defendant at that time indicated that wouldn't work for him because he worked with, I think it was cleaning alcohol for cleaning. So a scram would be appropriate. We then get the report that tests positive for alcohol. He says it was mouthwash. Now we're hearing today that he thinks it was something he didn't know had alcohol in it. That sounds to me like excuses to allow him to drink. And I think that I don't think he wants to be drinking, but I don't think he can be trusted on his own not to drink. So I believe remand is necessary for his own betterment, in this case, as well as for public safety and compliance.
It's about the best thing I want to do at this point. Let's get you treatment.
Thank
you. Your Honor, if the court is inclined to remand him today, I would ask that he be allowed to be released to treatment as well. My client is not arguing that he is not struggling. He wasn't drinking at the time of this. I'm sorry, he wasn't driving at the time of his recent incident. The one that brings him before the court to let the court know that he was at a restaurant trying to get something to eat, and the police were called. But he is struggling. He's not denying it. He's not going to deny it to you. He's not going to deny it to anyone. It's just it's an addiction that is socially acceptable at times, and he is struggling, Your Honor.
Turn this to the 20th. I will potentially allow release to inpatient treatment if you.
I'll get you in
met
order, Your
the order. That would have to be with the Yes, Tether. So I'm adjourning it to the 20th. I'll sign that order. And at this point, I don't think you know what you really want to say, because Mr. Cook is right. Everything that you're saying is making excuses. And frankly, that's what alcoholics do, particularly when they're caught. You just keep making excuses. So you have to make a determination as to really whether or not you want to deal with this or not. But you'll have time to think about it. Defendant's bond is revoked. Andrew.
Thank you, Your Honor. I'm gonna get this back.
Thank you, Attorney.
Welcome, sir. Is it? Seriously? Court calls case, People versus Jeremiah Young.
Assistant Public Defender Emzo Hutchins on behalf of Mr. Young, who is approaching. Mr. Young, please state your name for the record.
Jeremiah Young.
Thank you, Your Honor. We would be requesting an adjournment for further discovery.
That discovery is voluminous, and that is 101. The defendant made to the victim's number exclusively after being arraigned and told not to have contact with her. I've not had a chance to review those calls today or tomorrow. And at this time, his bond to be revoked along with his phone and texting privileges. This is an extremely serious domestic violence case involving strangulation to the point of urination. The defendant telling me that he killed her. She tried to get help. I do believe at some point this could even potentially have an AWIM added to it at exam, given the facts of this case. So this is going to be estimates bond be revoked for the 101 jail calls he made exclusively after being arraigned, and then his phone and text be revoked as well.
Thank you, Your Honor. His bond, I believe, is already set at 75,000 cash or surety. And which I feel for this
7 or 2? 7, okay.
Which is already incredibly high and could be $1 million, and it wouldn't really matter at this point. As for his phone privileges, we would just ask the court to ask the jail to block that number. And then that problem is solved, but he can still communicate with his family with regards to this case moving forward.
I'll adjourn this out to August 27th, 2026, 9 a.m. Defendant's phone privileges and texting privileges are hereby ordered revoked. I would also, given the number of calls to specifically the victim in this case, I think it's appropriate that this defendant bond be revoked. So his bond is also revoked. Thank you.
Thank you, Your Honor.
So what are all these?
Out of custody and its facilities that.
So like that out of custody are still here.
Yes, sir.
Okay.
Yes, and that's the rest of the file.
Court calls case, the People versus E.B. Tenga.
Good afternoon, Assistant Public Defender Lauren Perny on behalf of Mr. Kinga. Your Honor, Mr. Kinga changed his number, got a new number. We didn't have,
State your
oh,
name.
I'm sorry.
Stevie Kinga. Thank you.
We were unable to connect before today's date. He did give me an updated number, so
Have an updated number now.
yes.
You're asking for an adjournment?
Yes, please.
Turn it to August 27th, 2026, 9.
Thank you.
Thank you.
Thank you.
Court calls case of the People versus Jonathan Carey.
Assistant Public Defender Jay Bellinger on behalf of Mr. Carey, who's an appearance via Zoom, Your Honor.
Sorry, what? No, I got it.
Mr. Carey, can you please state your name for the record?
Yeah, Jonathan Carey.
All right, what are we doing?
Your Honor, at this time, we're asking to set this matter for preliminary examination. All discovery is complete from our understanding.
People have their witnesses available the 18th. Preliminary examination, August 18th, 2026, 9 a.m. That's before judge. Before me.
Thank you, Your Honor.
Thank. Court does call the case of People versus Tommy Lee Clark Jr.
Stephanie Kane on behalf of Mr. Clark, Your Honor, who is appearing by Zoom. Your Honor, at this time, we are asking for an adjournment for investigative and mitigation purposes. I am trying to prepare a motion on his behalf, as the court is aware. I see a little bit more time on it.
Your name, sir? I'll adjourn it to September 3rd, 2026, 9 a.m. Bond continued.
Excuse me, Mr. Simpson.
Yes, sir.
Just trying to see, am I able to get testing moved because I'm currently going to be on probation through another Monday.
I can't make out what you're telling me, sir.
Mr. Clark, your signal is really bad. You're actually frozen and we can't hear what you're saying.
Oh, sorry. Can you hear it now? Hi. Is that fine?
Yeah, I can hear you. Go ahead, try again.
Okay. I'm currently about to be on probation through Oakland County on Monday, and I was trying to see can I be excused from going through this testing since I'm going to be testing with them.
Well,
We have results from them, Your Honor.
but you're not on probation with them yet.
Well, I will be this coming Monday. Yeah.
Hey, but after we see what the order is, then I can take a look at it. I can't answer it in a vacuum like that, sir.
Mr. Clark, you have my information. Call me on Tuesday and I will submit a request to the court, but you have to call me so I can submit the request, okay?
All right.
Thank you.
All right.
Court calls the cases of the People versus Danina Combs.
And Assistant Public Defender Nick Buckovich on behalf of Ms. Combs, who should be appearing via Zoom.
Ms. Combs? That may be her.
So I believe that is, so she's.
Can you hear me?
State your name.
Go to the phone and unmute. Danina.
Is that her? Okay. What are we doing?
At this time, Your Honor, I will be requesting an adjournment. We're looking into some other forms of resolution that may include looking into outer county sobriety court. So I would ask for a slightly longer adjournment because I need a time to be able
to try to find. Adjourn it to September 3rd.
I appreciate that, Your Honor.
2026, 9 a.m. Thank you.
You're done.
Thank you, ma'am. September 3rd.
Okay, thanks, Judge Simpson.
You're welcome. Court calls the case People versus Malik.
She's gonna leave here. Okay. You can't. They won't let you. Oh.
You, Mr. Cook?
Come on, Mr. Cook. All right, Judge.
That wasn't your fault. Creature got away.
That's right.
Malik Cook.
Judge is setting this matter for preliminary exam.
Got all discovered.
To our knowledge, Judge, yes.
Are there witnesses available the 18th? Preliminary examination, August 18th, 2026, 9 a.m. for Judge Moore.
Yeah.
Thank you.
Same building.
Thank you, sir.
Thank you, Judge.
Okay. Oh. Extra meat. Court calls the case People versus John Costello.
Assistant Public Defender Jay Bellinger on behalf of with Mr. Costello. Your Honor, my understanding is that there was a no bond warrant that was issued, I believe day before on this matter. Mr. Costello did come into our office. I was able to speak with him on the, at that time. That was yesterday. We did,
I issued a warrant yesterday.
it was either yesterday, I believe.
Yes, I did.
We gave him bus fare to be here. Unfortunately, I don't see him here today at this point.
So what I will do is I will leave the current warrant outstanding.
Thank you.
Court calls case People versus Kentria Cummings.
Ashley Bashir on behalf of Kentaria Cummings.
Your name, ma'am?
Kentaria Cummings.
Thank you.
Your Honor, we are requesting a 4-week adjournment. We have put in a referral to the AIM division in our office just to see if a resolution is possible at this.
August 27th, 2026, 9 a.m. bond continues.
Thank you, Your Honor. Thank you.
Court calls case People versus Richard Curry.
Good afternoon, Your Honor. Payment book for the people.
Good morning, Assistant Public Defender Lauren Perny on behalf of Mr. Curry. Say your name, please, sir.
Richard Curry.
He'll explain to him about the dress code, I presume.
Yes, Your Honor. So Mr. Curry and I were unable to speak. He did give me updated contact information today. There's some investigations we are looking into, and Mr. Curry is also considering retaining counsel. So we're asking for an adjournment.
How much time would he need to retain counsel? I mean,
Kind of depends on, I think, how the investigation goes. Is that fair? So,
Realistically, if I'm gonna hire an attorney.
okay.
yeah.
So we'll just ask for the next available date, Your Honor. I think.
August 27th, 2026, 9 a.m.
Thank you, Judge.
Court calls case People versus Evan LeBron.
Assistant Public Defender Jay Vaughn on behalf of Mr. LeBron, who approaches. State your name for the record.
Evan LeBron.
Your Honor, we just we just got the discovery for this yesterday. I'm just asking for a brief adjournment.
27th. August 27th, 2026, 9 a.m. Thank you.
Thank you. We'll be in touch, okay?
Okay.
We'll be, yeah, 1 All right, you bet.
Court calls the case the People versus Amber Dunson. This facility did not sign in Oakland County. Pardon?
Payment book for the people. Dunson.
They did not confirm the writ, so I'll adjourn this out to 27th of August. Court calls the case of the People versus Saquon McKinney. Wayne County Jail did not confirm or did not sign in with this person.
To another facility, so.
So he's someplace else right now.
In Oakland now, Your Honor, yeah.
Oakland.
I saw him last week.
All right. So what I will do is I will adjourn that out to September 3rd, 2026, 9 a.m.
Thank you, Your Honor.
Court does call the case of the People versus Mamadou Diallo.
And my dad is on behalf of Mr. Diallo.
And were you able,
So he was transferred. I was able to talk to someone from the jail. I explained to them the time difference. They were supposed to sign in. I don't know why they didn't. I was not able to meet with him, but
I have to give this federal question, I have to give them once.
I did clarify. We can do
I don't know if he needs to.
We can, 3 weeks? Okay. Probable cause conference, I'll adjourn this out into the 27th.
Thank you.
Court does call the case of the People versus Stephen Givan.
Good afternoon, Raymond Goodall.
Some Public Defender Jay Vaughn on behalf of Mr. Given.
I'm sorry. This is a forensic center case and they did not sign it. did not sign in. I'll adjourn this out September 3rd.
Thank you, Your Honor.
That'll be adjourned to September 3rd, 2020. Court does call the case People versus Antonio Williams. This is also a forensic case. They did not sign in. I'll adjourn that one also out to September 3rd, 2026. Is that it? Finally. Court's gonna take a recess. Those of you on my 12:30 call, be a little bit behind, but we'll get out of here before I start that one. What do you say?
Sorry, 4:45 for so many people.
Trying to set my schedule? Oh, you're trying to set their schedule. Oh, you want them to eat?
They're a lot nicer.
No, really not. Not cooked.
Okay.
In fact, we have a rule here, do not feed cook,
Oh, very good.
because it's really ugly. It's like a gremlin. All right, so anyway, what I will do, court is standing recess, that'd be fine, about that time.
Arise.
Yeah, or is 45. I don't know.
Court is now back in session. Honorable J said presiding.
Folks, you're good. You're good. I do appreciate it. Just stay where you are. You may be seated, folks. Court does call the case of People versus Cody Wellman. Counsel, state your appearance.
Yes. Set for me, Your Honor. Or the prosecutor first.
Prosecutor already went.
Oh, okay. Good afternoon, Your Honor. Good afternoon to your staff. May it please the Honorable Court. My name is Todd Wilson Perkins, P 55623, appearing on behalf of Mr. Bowman.
Mr. Bowman, can you state your name?
Yes, Your Honor. Cody Bowman.
Got it. Okay, what are we doing?
Your Honor, I was awaiting a response. I know that if we could pass this matter for a moment, I did want to reach out to whoever's in the courtroom right now, or
Perkins, you sound like the clown at a fast food joint. I can't hear you.
Okay. If we could pass for a moment, I'm going to change systems. We could just for a moment. I'll raise my hand when I'm ready.
I don't know what he's. I will pass it. Is that what it was? Thank you. I'm glad you could decipher that. We'll call it back up momentarily, Mr. Perkins. Thank you. Court calls the case People versus Lisa Keebler, and her attorney is in back dealing with another case, so wait on that. Court calls the case People versus Damon Cooper.
Good afternoon, Your Honor. Did you say that you want defense counsel to place our names on the record without? Good afternoon. If it please the court, Attorney Sharon Jones, P number 57113, on behalf of Mr. Cooper, we appear by Zoom with the court's permission.
Mr. Cooper?
Yes, Your Honor.
State your name, please.
Damon Cooper.
All right. What are we doing on this case today?
Your Honor, we would like to proceed to exam. I've received a discovery. I have requested additional discovery, but I believe I've gotten pretty much everything that they have available currently.
So you currently have all discovery that you would need?
Yes, I believe so.
All right. People have their witnesses available the 18th. Preliminary examination will be set August 18th, 2026, 9 a.m. before me.
Thank you.
All right. There'll be no adjournment based upon the fact that you didn't have the discovery.
Thank you, Your
Okay?
Honor.
Thank you. Bond continued. Court calls case People versus Kwame Edwards.
On behalf of people, Your Honor.
Good afternoon, Your Honor. Edward Lucas on behalf of Kwame Edwards.
Your name?
Kwame Edwards.
Thank you, sir.
I know there's some negotiations still going on. I'd asked for 3 weeks for nothing.
September 3rd work for you?
That would work.
Limit, our probable cause conference is adjourned September 3rd, 2026, 9 a.m. On continue. Thank you. Court calls case People versus, is it Maccabee? Kaba?
That's both the people.
Edward River, something, Mr. Kaba, who will be approaching.
Marty Bay Kabu. Thank you.
And I'm also asking for an adjournment, finishing negotiation.
We're gonna give you the same date.
Sounds good.
September 3rd, 2026, 9 a.m.
Thank you, Your Honor.
Thank you. Bond continue. Court calls case People versus Cameron Harding. Harden.
Ashley Phelps for the people.
Good morning, good afternoon, Judge. On behalf of Mr. Cameron Harden, Attorney Nicholas North, PA 6482. Mr. Harden, please state your full name for the record, sir.
Cameron Harden.
Thank you. What are we doing?
So, Judge, I'm just asking for an adjourned PCC. I do have the discovery. I just need more time to review it.
All right.
Maybe a couple weeks, please.
20th or 27th, which would work better for you? Don't know why I'm asking.
The 20th works great.
The co-defendant went to the 20th. All right. Probable cause conference, August 20th, 2026, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you. Court calls case of the People versus Alan Hodge.
Ashley Phelps for the people.
Good afternoon, Judge. On behalf of Mr. Hodge, Attorney Nicholas North, PA 6482. Mr. Hodge, please state your full name for the record, sir.
Do we have him in there?
Hello, I am Alan Hodge.
I lost. State your name again, sir.
Alan Hodge.
Got it. Okay. All right, what are we doing?
Same thing, Judge. I'm just asking for an adjourned PCC so I can have more time to review the discovery. I was just assigned the case this week.
August 20th, 2026, 9 a.m.
Thank you, Judge.
Thank you. Court calls case People versus Timothy James.
Ready, Your Honor.
Jacob Kennedy for the people, Your Honor.
Oh,
Your Honor.
boy.
Thank you. Joe Simon, Mr. James.
No, that was my way of showing pleasure for you being here.
Thank you, Your Honor. Touched my heart. Your name, Timothy James. Your Honor, you should have a green sheet.
I do.
We're going to have my client screened by the 14A4 sobriety court. There's also a referral form that they told me to submit. I don't know if that's written for your honor to submit, your court staff to submit it, but I'll submit it if that's the right thing. But anyway, asking to adjourn.
Say that again.
There's a referral form they ask us to fill out, really for your honor staff to submit it to them, but
Correct.
okay, so that's all I just wanted.
Should get over to them.
All right, so that's what I was just verifying, but anyway.
Right. That's what I think.
That's
not my staff.
All right, then we happy to have that happen. That form says 2 weeks, but in my experience, Your Honor, can we have about 4 weeks to adjourn the PCC for that evaluation and come back?
Why are you nodding?
I'm in total agreement. In my experience, it also takes. It by much less years in experience.
Wow.
Hurtful, but
Simon,
hurtful but fair. Hurtful but fair. I can't say.
Oh no, that was like I'm calling you really old. Like
can't say
much less experience.
Can't say anything.
Kennedy's gonna get himself in trouble. Probable cause conference, September 3rd, 2026, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you, sir.
Thank you, Your Honor.
I don't care about you, Ken. I mean, you're welcome. Court does call the case People versus Stephen Klein.
Ashley Phelps for the people.
And Judge, good afternoon. Vincent Haysha with and on behalf of Mr. Klein, who's present on Zoom. No objection to that.
Mr. Klein, can you state your name, please? Oh, there he is. You have to unmute. I see your lips moving, but.
I apologize, Your Honor. Stephen Klein.
Okay, no apology necessary. All right, what are we doing?
Judge, if I could, I spoke to Mr. Cook. We have an offer that will be reduced to a misdemeanor. However, I did just get the digital discovery. If we could set for a PCC on the 20th, if the court's available, I suspect it'll be a plea. But if it is, we'll obviously be in person. And if it isn't, then we'll set for an exam. But I don't think we need to set for exam at this point.
They just needed it the 20th.
20th would be fine, unless if it's going to be a plea, judge, would the 20th be a date that we can keep for that, or will that date change?
Say that again.
If it results in a plea, could we plea on the 20th, or would that be?
Oh yeah, absolutely.
Okay, I can make the 20th work.
That will not be a date we can take testimony. So if you're looking for
Right.
an exam date, we have to get a different.
No, just a PCC.
No, he just wants to make sure we can plea at that time. Yeah, absolutely, counsel. So I'll adjourn it to August 20th, 2026, 9 a.m.
Excellent, Judge. Thank
Thank
you.
you.
Yep.
Court calls the case People versus Patrick Lay.
Good afternoon, Your Honor. Raymond.
Good afternoon, Your Honor. Michael Vincent on behalf of Patrick Lay.
Good afternoon, Mr. Vincent. How are you, sir?
Old,
Okay.
older than Simon.
Older than Simon, yes. All right. They really let you travel alone. Nobody's here from your office.
Everyone's gone. Ellie's getting married tomorrow. I'm here all by myself.
Oh, boy. Okay.
There was agreement, I believe,
My understanding is the defendants paid back the restitution on this case based in consultation with the victims who were dismissed.
accepted.
No objection.
No.
Case is dismissed.
I'm in for Mr. Goldstein on a Javon Mills. And he just needs a prelim date. If I could do that one also, because I'm old. Remember, I'm old.
So, Mr. Vincent, when have you ever walked in here and been able to call your own case?
How much time do I have to try to? It was suggested.
Let's call it for the.
It was suggested.
Wait, is this it? Only you.
Thank you.
And it will never happen again. Court calls the case, People versus Javon Mills.
Then on behalf of.
The Mills,
Seriously?
Mills,
No, he's right here.
Michael Vincent, standing in for David Goldstein on Javon Mills. Step forward, state your name, sir.
Go ahead. All right. You have no objection to Mr. Vincent stepping in for this?
No, sir.
Thank you.
David asked for a prelim exam on dates 8/25 or 9/1.
You know,
It's not me demanding.
no,
Wait,
I met somebody earlier today. I have no qualms about shooting the messenger. I just,
I have a lot of qualms about dying.
is discovery complete?
My understanding, yes.
Will the people have their witness? I don't know why I allow this. Will people have their witnesses available the 25th? How Goldstein went up on my list too. Set preliminary examination, August 25th, 2026, 9 a.m. for Judge Washington.
All right, thank you. Make sure you call David up, okay?
Court calls the case People versus Gerald Barhofer. All right. Like who isn't?
Good afternoon, Your Honor. Deanna Kelly appearing on behalf of Mr. Marhofer. He's present to my right. Could you state your name?
Gerald Marhofer.
Thank you. Your Honor, we are respectfully requesting a short adjournment. The prosecutor and I are engaging in conversation that might result in a resolution.
27th of the 3rd. I don't know why I'm being so nice. Go ahead.
We're always nice and I appreciate that. And we would
Wow.
love to come back and
Better about me.
we would come back and see you on the 27th.
27.
Yes.
PCC will be adjourned August 27th, 2020.
Thank you, Judge.
Thank you. Bond continued. Court calls case People versus Teresa Heichel.
Good morning, Your Honor. Marcia Crater on behalf of Mr. Heichel, who's on Zoom by permission. Ma'am, can you please state your name?
Teresa Heichel.
Thank you.
Your Honor, discovery is not complete. We're asking for a 2-week adjournment for 911 calls.
August 27th, 2026, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you. Court does call the case People versus Matthew Moy.
Your Honor.
And so this is all 12:30.
Yeah. 149.
Did good, relatively good this morning.
Good afternoon, Your Honor. Marcia Crater on behalf of Mr. Moy. Sir, can you please state your name?
Matthew Thomas Moy.
How you doing, Mr. Moore?
Pretty good, Your Honor. You?
Trying. All right. I have before me a plea form that indicates the defendant will be pleading guilty to the charge of attempted resisting and obstructing a police officer. The 1-year offense. Upon a successful plea to that added count 2, count 1 would be dismissed. That is the court's full understanding of the agreement.
That's correct, Your Honor.
That's correct, Your Honor.
May I have him sworn?
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes.
Lower your hand. State your first and last name and record.
Matthew Moy.
Sir, it is this court's understanding that you're going to be pleading guilty to the charge of attempted resisting and obstructing a police officer. That is a misdemeanor punishable by up to 1 year incarceration, a $1,000 fine plus court costs. Do you understand that?
Yes, Your Honor.
You understand also that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Perry in the 15th District Court.
Okay.
Still wish to plead guilty?
Yes, Your Honor.
To that charge, how do you plead?
Guilty.
And you understand that by pleading guilty, you'll not have a trial of any kind?
Yes, Your Honor.
You signed an advice of rights form, is that correct?
Yep.
Question regarding any of those rights?
No.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that.
Yes, Your Honor.
Then you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
I am.
Were you on probation at the time of this offense?
Yes, Your Honor.
Then I have to advise you that your guilty plea in this case could be considered a violation of that probation. You understand that?
Yes, Your Honor.
Is considered a violation. The judge in the other case could sentence you to the maximum allowable under the other charge or charges. You understand that?
Yes, Your Honor.
Understanding that, you still wish to plead guilty to this charge?
Yes.
Anybody promised you anything other than what's been stated here today on the record to get you to plead?
No.
Anybody threaten you or coerce you in any way?
No.
Doing this voluntarily?
Yes, Your Honor.
Of your own free will?
Yes.
And also because you believe that you're guilty of this offense?
Yes.
February 18, 2026, at the location of Packard near Thompson Street, City of Ann Arbor, Washington County, State of Michigan. Did you come into contact with University of Michigan Police Department officers?
Yes.
What happened?
I was pulled over. I think I gave them my ID. They went back to run my name, and I exited the vehicle and tried to run, Your Honor. Made it to the fence. When I realized that there was another fence behind it and a tree, and there were police officers behind me, I just surrendered, but I did run.
Didn't work.
No, I didn't. Yeah. Nope.
All right. And you realized they were in the performance of their lawful duties?
Yes, Your Honor.
Sir, I do have to advise you that if between the time I accept your plea and the time of sentencing, if you commit misconduct as defined under the Michigan court rules, you would not be entitled to withdraw your plea, and the court would not be bound by any sentence evaluation or recommendation. You understand that, sir?
Yes, Your Honor.
All right. Counsel, are you aware of any other promises, threats, or other inducements led to this plea?
I'm not, Your Honor. Thank you.
Defense is not, Your Honor.
And have I complied with the court?
Floor satisfied.
Defense is satisfied.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Pre-sentence investigation is ordered at 15th District Court probation. Sentencing will be
August 28th at 8:30.
August 28, 2026, 8:30 before Judge Perry. Bond will continue.
Thank you, Your Honor.
Razan did it. Court calls the case, people versus Mikey Nunn.
Your Honor, Raymond Cook for the people.
Good afternoon, Your Honor. Robin McCoy, P 63057, appearing on behalf of Mackay Nunn. We are
Okay,
appearing.
got the name wrong. I get it. All right. Nunn, can you state your name, please?
Good morning, Your Honor. My name is Mackay Nunn.
Or,
I'm sorry,
All right.
afternoon.
It's okay. No, we're good. All right. What are we doing?
Well, we have been talking with the prosecutor about working on a potential resolution. I had the understanding that there was a video, but we've been emailing about and making the request. We haven't seen the video yet. We'd be asking for an adjourned PCC, and we also did. His mom is present via Zoom. We want to address the bond as well.
Probable cause conference will be adjourned August 27, 2026, 9 a.m. As to bond.
Okay, Your Honor, as of right now, he is under house arrest. But we emailed the prosecutor. We wanted to update the court. He is seeing a therapist. He has applied to school and he has job prospects. I spoke with his mother, he and his mother yesterday. They're asking if the bond could be modified so that he could have a tether and that he no longer be under house arrest. They said that one of the jobs prospects would be he would be working with a relative and under their supervision.
Response.
I know Your Honor's already familiar with the circumstances of this case and of this defendant. I think if we could get definitive dates and times that he would be working in a location, I have no issue with an exception for those carve outs. So I'd just like to make sure that we have firm plan in place before just releasing the house arrest in its entirety.
And I would agree with the people on that. I don't
Okay,
have
so-
a problem making exceptions, but I will not just give carte blanche regarding this tether.
Okay, and then I just want to be clear. So you want definitive times for his work schedule and for his school schedule?
Yes.
Okay, we can get that.
All right, get that over to the prosecutor. It sounds like there would be agreement, and then you guys just prepare an order and we're good. All right.
Okay.
In all other respects, bond will continue. Thank you.
All right, thank you, Your Honor. I hope you and your staff, everybody else has a great day.
You do the same. Court does call the case, People versus Denise South.
As results to the people.
Good afternoon, Your Honor. Attorney Ryan Rams there on behalf of Ms. Self, who's approaching. Ms. Self, could you please identify yourself, the record?
Hi, Denise Self.
I have before me a plea form that indicates that the defendant will be pleading no contest to 2 charges. The first charge being count 4, which would be the possession of a weapon under the influence offense. And count 5, an added count 5 of operating while intoxicated. That's being the 93-day offense. Upon a successful plea to that those charges, counts 1, 2, and 3 would be dismissed. Defendant is agreeing to enter into and participate in the 14B drug court. That's the court's full understanding of the agreement.
Yes, Your Honor.
That's ours as well. Thank you, Your Honor.
May I have her sworn, please?
I'm swearing affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
Lower your hand, state your first and last name.
Denise Self.
Ma'am, it is this court's understanding that you're going to be pleading no contest to 2 misdemeanors. Is that your understanding?
Yes, sir.
First one being possession of a weapon under the influence. That's a misdemeanor punishable by up to 93 days in jail, $100 fine plus court cost, and mandatory forfeiture of the weapon or device. You understand that?
Yes.
The other charge is the charge of the added count 5 of operating while intoxicated. That's a misdemeanor punishable by up to 93 days in jail, up to a $500 fine plus court costs. The court could order community service or any rehabilitative services the court deems necessary. The court could also order your vehicle forfeited or immobilized and could order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand all of that? Do you understand what a no contest plea is?
Yes, Your Honor.
2 things about it I have to make sure that you understand. The first thing is that it means that you're not further desirous or wanting to contest this charge. You understand that?
Yes.
Second thing is that for purposes of sentencing, the court's going to treat you the same as though you had pled guilty. You understand that?
Yes.
You understand also, ma'am, that while I'm taking your plea, I would not be your sentencing judge and you would be sentenced before Judge Washington in the 14B District Court.
Yes, Your Honor.
Basis for the no contest plea?
In this case, civil liability, Your Honor.
All right. Ma'am, to the charge of possession of a weapon under the influence, how do you plead?
No contest.
To the charge of operating while intoxicated, how do you plead?
No contest.
Now, you understand that by pleading no contest, you'll not have a trial of any kind.
Yes, Your Honor.
All right, you signed an advice of rights form, is that correct?
Yes, Your Honor.
Any question regarding any of those rights?
Oh, yeah.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand that by pleading no contest, you'll be giving up those rights as well as all the rights that are contained in that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
No, Your Honor.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily and of your own free will?
Yes, Your Honor.
And also because, well, I won't ask that second part. Court has been handed Washington County Sheriff's Office report for their case number 2496598. Any objection to the court having reviewed that report?
No, Your Honor.
Not from us, Your Honor. Thank you.
Based upon a review of that report, the court does find that there's sufficient factual basis in which the court could determine the defendant's guilt of these offenses. Ma'am, I do have to advise you that if between the time of my acceptance of your plea and the time of sentencing, if you commit misconduct as defined under the Michigan court rules, you would not be entitled to withdraw your plea and the court would not be bound by any sentence evaluation or recommendation. You understand that?
Yes, Your Honor.
All right. Is counsel aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor. Thank you.
And have I complied with the court rule?
Floor satisfied.
We're satisfied, Your Honor. Thank you.
Court will accept the defendant's plea of no contest to counts 4 and 5. Counts 1, 2, and 3 are hereby ordered dismissed. Pre-sentence investigation and report and screening assessment is ordered at 14B District Court. Sentencing in this matter will be
September 10th at 10 a.m.
September 10th.
Is it possible to get a different date than that?
I'm sure in some universe there is, but not here.
Okay.
So I will give you
Oh, wait, that's fine. I was thinking August anyway. Never mind.
okay.
I don't even know what month it is. Sorry, Your Honor.
September 10th, 2026. What time?
10 a.m.
10 a.m. before Judge Washington. Bond will continue.
Your Honor.
Thank you, Your Honor.
Have a wonderful day.
You do the same. That's in just seconds. Court calls the case People versus Jason Sibley.
For the people, Your Honor.
Good afternoon, Your Honor. Ed Latrisky appearing on behalf of and with Jason Sibley. We appear by Zoom with no objection.
Sibley, state your name, please.
Jason Sibley.
All right, what are we doing?
Two things, Judge. I'm going to ask that you set it for a prelim, but I'd also like to address the court on bond, if I might.
Is all discovery complete?
Yes, sir.
All right, people have their witnesses available the 18th. Preliminary examination will be set for August 18th, 2026, 9 a.m. before for me. All right, that's an in-person proceeding. As to bond.
Your Honor, my client puts on seminars for a company that he's been working for quite some time. He actually puts these seminars on for adults. I don't want the court to think he's teaching children or anything. He does travel occasionally. I understand the court's going to want some specificity if the court does allow him to travel, and that's not what I'm asking for today. What I'm asking for today, he has an ankle bracelet on, Your Honor. And I mean, this is very unusual. I don't think I've ever even asked the judge to increase the cash portion and let him off. He is laid off with pay right now because of that ankle bracelet. The company does not want him addressing a large group of people.
Response.
Your Honor, this is criminal sexual conduct, third degree matter. I do think it would be more appropriate for this to be addressed. Preliminary examination.
I think I'm going to agree with the people. I'm not going to remove that without a further understanding more of the factual circumstances of the particular case. I also don't, just state this, that I don't think that a cash component necessarily suffices for the security and safety of the public that a monitoring or GPS tether does. So while I appreciate and understand the offer, I'm not going to do it that way. So motion for a reduction or change in bond is denied at this time.
Thank you, Your Honor.
Thank you.
Thank you.
Court calls case B versus Grady Frost.
Actually, call this for people.
Good afternoon, Your Honor. Alexandria Taylor appearing on behalf of Grady Frost, who is present via Zoom. Mr. Frost, can you state your name for the record? I see him on here. Mr. Frost?
Oh, I wait for Mr. Frost. Miss Taylor, she doesn't come down and see us anymore. Did you notice that?
I
Huh?
do,
No,
Judge.
she
Don't
comes-
say that.
She just pops in a Zoom occasionally and just like never writes, no postcards, no nothing, don't even get an email. But it's
Stop.
okay. I don't know. I'm not taking any offense whatsoever.
Stop it, stop it. Is it possible, is he on here or can they send a prompt for him to unmute?
I do see
Your Honor.
a box with his name on it, but Grady Frost. Do you think he dropped at one point?
Yeah.
All right, let me pass it. Oh, no, hang on. Mr. Frost? He just unmuted, but I don't. Oh, there he is. Oh, I see why we couldn't hear him, because he's got that University of Michigan background. All right.
Agreed.
He's sideways. He's sideways, but I see him. Mr. Frost, can you state your name?
This signal is terrible. Absolutely terrible.
I don't know if he's hearing me.
I'm not sure because I heard him say my name. Mr. Frost, can you hear us?
I can't hear nothing.
Oh, well, we can hear him though.
Right. What were you intending on doing? He's there, but
Just for an adjournment. I just came aboard to get discovery and then have the opportunity to talk to the prosecutor and see what we could do with this.
all right.
We did have a bond request if the court.
Sure.
This is terrible.
Will August 27th work for you, counsel?
Thursday, August 27th?
Yes.
Yes, I can make that work, Judge.
All right, August 27th, 2026, 9 a.m. I should make it in person, make her come down here, but I'm not gonna do that. I'm not that bad.
Pleasure to see Ms. Taylor.
I know.
I appreciate you. And the prosecutor. I love hanging out with you all.
We just lost the defendant again, Your Honor. I see that his square seems to have disappeared.
It did.
Your Honor, I do see in my file that at the time of arraignment, he was ordered to do once a week test. However, he was on the Zoom with his camera on for quite some time while we were waiting and was exhibiting some behavior a little bit strange. I would ask the court order him to report within 24 hours for testing. I haven't received anything from community corrections, so I don't know how the testing is going. If I have received it, it's not in my file.
And I don't have anything that does that. Counsel, you have any well, I think I did not see anything, but based upon the representation prosecutor.
But I mean, I can tell him to report within 24 hours to community
Yes,
corrections.
why don't report within 24 hours for a drug test. All right.
Okay.
And I will be signing order to that effect.
Okay. All right. Very well. I'll make sure I communicate that to him, Your Honor.
Thank you.
And bond will continue otherwise.
All right. Thanks. Great seeing you, Judge and Madam Prosecutor.
Take care.
Thank you. Bye.
Bye-bye. Court calls case, People versus Keith Davis. Oh boy, here we go.
I already read off the thing. I don't have.
What?
Do I have to do the thing again or no?
She appear already? She appear?
I did, yeah.
Did? Oh, memorable. All right. No, you don't have to do that. Go ahead.
Okay, thank you, Your Honor. Ashley Hannibal for Mr. Davis is appearing by Zoom,
Davis?
I think.
Yes, I'm right here.
Davis, great. I got it. Okay, what are we doing?
Your Honor, we'd like to adjourn this. We've had trouble reaching Mr. Davis, so we just would like a couple of weeks to discuss his case.
During the matter to September 3rd, 2026, 9 a.m.
All right, thank you.
Bond continues. Court calls case of the people versus Jerry Doss.
Good afternoon, Your Honor. Raymond Copeland.
Assistant Public Defender Zach Venue on behalf of what I do not believe with Mr. Doss.
I never had better.
They're right here.
They're right there.
Yes, sir.
Okay, Your Honor, we've been unable to locate him at this point. I guess I would ask to briefly pass it in case he is here.
You had him checked in though. All right, I'll pass it.
Thank you, Your Honor.
Nicholas Dracos.
Ask about this with people.
And Assistant Public Defender Nicholas Bukovich on behalf of Mr. Nicholas Dracos.
Why are you smiling at me? Where is he? You have.
Now he should be here.
About that,
Oh, you were stalling. Okay, all right, I get it.
Your Honor, we submitted a request to adjourn for further negotiations. And also, I believe that I also stated that I received some documents from Mr. Dracos that I'd like to review and potentially share with the prosecutor.
Is your client here?
He is on Zoom. He's been on
State.
time.
Hello, sir. Nicholas
Yes.
Dracos.
Thank you, sir.
Thank you, Your Honor. Sorry about that.
No, it's all right.
My timing.
Probable cause conference will be adjourned to September 3rd, 2026, 9 a.m.
Thank you, Your Honor.
Bond continued.
Thank you.
Court calls case of the people versus Kiera Eckridge.
Assistant Public Defender Zach Venue, with and on behalf of Ms. Eckridge, who's present via Zoom. Ms. Eckridge, can you please state your name for the record?
Here, Eckridge.
Thank you.
Your Honor, we just received an offer from the people yesterday. I need time to relate to my client. I would request an adjournment.
Probable cause conference, August 27th, 2026, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you.
Thank you. Court calls case people versus Kendall Green Austin.
Assistant Public Defender Hannah Apple appearing on behalf of Mr.
Mr. Green Austin, will you state your name for the record?
Kendall Green Austin. Take your hands out of your pockets. What are you doing?
Your Honor, we're asking for an adjournment. I've requested some mitigation information, so we'd like some time to prepare that.
Adjourn it to September 3rd, 2026, 9 a.m.
Thank you.
Right, Your Honor. I passed that one for a reason. Court calls the case of people versus Aaliyah Gregory.
Padma Davish on behalf of Miss, I've actually forgot the last name.
Gregory.
Gregory. Your Honor, to my understanding, we have no contact information for her, no address, no email, no phone number. I'd ask for an adjournment. Since it's her first BCC.
Bench warrant will issue for defendant failure to appear. Don't look so disappointed. You knew.
I tried. I'm
happened.
not.
You knew what was going to happen.
Thank you.
Bench warrant. 10,000 cash surety. That warrant will issue immediately. Thank you. Court calls the case. People versus Taiwan Griggs.
Stephanie Kane on behalf of Mr. Griggs.
No, take your time.
I dropped my phone.
by Zoom. Mr. Griggs, could you please state your name for the court?
Hi, Judge Honorable Simpson, Taiwan Griggs.
Thank you, sir.
And Your Honor, we're just asking that this case set for preliminary.
Discovery is complete.
Yes, Your Honor.
People, are there witnesses available the 18th? Preliminary examination, August 18th, 2026, 9 a.m. That's before Judge Moore. Court calls the case of the versus Dean Hodder.
Thank you. With, on behalf of Mr. Potter, who approaches.
You did it, right?
State your name.
Sir.
Dean Hodder.
Thank you.
Your Honor, we just received an offer from the people. Mr. Hodder needs some time to consider it, so we'd be requesting a brief adjournment and then briefly as to a bond condition out of that has to be heard as well.
I'll adjourn it to August 27th, 2026, 9 a.m. As for bond.
Hey, what time should I get here? 'Cause I got here at.
It'll likely
contact them approximately a week before you'll know what time block.
Okay, sometime after 12:30, right?
Your Honor, as to bond, Mr. Hodder has been on once a week drug testing since he was arraigned about 2 months ago. My understanding is that he has never missed a test or had a late test, and that the underlying case does not have any allegations of drug use specifically. Mr. Hodder is concerned about the cost of the drug testing, and he has been staying negative on his drug tests and believes that he will continue to do so in the future. But
sponsoring the people.
I don't think that was one of our original requests.
I don't think it was either. I'll remove the drug testing. All right. We'll send communication to community corrections, so you won't need to test anymore.
So August 27th.
August 27th.
All right,
Judge.
Thank you, sir. Court calls case People versus Hunter Hallis.
People.
This is about Hunter's Act venue. He is out in the hallway. I'm going to grab him.
Why don't you try to cover him, Bukovich?
Yeah, the answer is.
You don't like him, do you? Tell me what? Cannon, go sit down. You're just. I know there's no room.
Assistant Public Defenders Act venue with and on behalf of Mr. Hallis, who approaches. It is wearing pants this weekend.
Yes, he is. That's 2 in a row. Finally figured out the dress code. Your name, sir?
Hunter Hallis.
Thank you.
And Your Honor, as to the PCC, we would set for exam in this matter. Discovery is complete to our knowledge.
Complete. And would you have people available by the 18th?
Perhaps, Your Honor, but the people would also like to be heard on bond, given this bond violation report. Charges. In case this has content for cocaine case, Brennan has missed at least 2 tests. Actually, it's 4 tests. 2 were categorized as unable to provide.
Your Honor, as to Mr. Hallis would admit to missing the drug test. He does apologize for that. This is his first time being involved in the criminal justice.
I'm not so much concerned about the missing one as opposed to the cocaine.
As to
drugs, Mr. Bates.
As to the cocaine, Your Honor, Mr. Hallis at this point does believe that it may be a false positive. He did go to community corrections yesterday or 2 days ago to get it sent in for confirmation, which is still awaiting. So we would request an adjournment of the bond violation hearing to the PE date.
Your Honor, I know the court has a report, but there is a report from community corrections that indicates the voicemail on the phone left for community corrections was, "Hey, this is Hunter Hallis. I'm calling because I received a call this morning that my test came back positive for cocaine. I don't know if you guys maybe did something to it. I'm kidding about that. But hey, you guys are effing leeches. I got to come in, I guess, within 48 hours. I don't know how that's going to happen. You guys aren't open, but yeah, hey, tell me how the hell to do that, I guess. And also, I'm positive for buprenorphine. That's my Suboxone. I mean, I can give you guys the, I don't know, that they may have not faxed you or whatever. You guys are effing weird, but damn, this is way too effing long. It's pissing me off. Just because my dad's a drunk and filed a false police report. I had to deal with this stupid effing drunk. I'm tired. I have to deal with this. Or I got to deal with this. Excuse me. It's real fun. But yeah, please call me back and yeah, tell me how the hell I'm supposed to get over there.
Your Honor, Mr. Hallis.
That's a full phone call.
That is the phone call.
Yeah.
Phone call, Your Honor. Your Honor, as to the phone call itself, Mr. Hallis spoke to me about that. He does apologize for swearing in the phone call and for expressing his distaste for having to pay for a drug test. However, Your Honor, he did then receive I guess information as to how to get the drug test checked, and then did come in and do that with no issue. So for that reason, we would ask for an adjournment of the bond violation hearing date to the preliminary exam date.
Where's his proof of the prescription for Suboxone?
Anything with you now, sir?
Nothing with me now. No, I mean, I have to
What?
on everything with like my name on it, and
What'd you say?
I don't have it with me now. No.
How come you didn't provide it to community correction?
Thought they like faxed it over or something like that.
That what?
Left him a voicemail. But
Yeah, we know about your voicemails.
yeah. I mean, pretty
They
much,
asked you for proof of your prescription of the Suboxone, correct?
yeah.
You haven't gotten it to them.
I thought that it had already been sent, but I guess the
By who?
prescriber. And I can definitely.
Something's terribly wrong here. You haven't provided proof of your Suboxone.
Yeah.
That's
I mean,
a very, go ahead, what do you
I'm
want?
almost off of it anyways. Like I'm 3 days off of it right now, actually. Like I'm trying to finally get over that last gap. But I'm not really doing that with the prescriber. That's more of kind of my own regard. Like they're taking this a little too long.
Are you gonna do this yourself?
Trying to.
Yeah, okay. You still want this set for exam?
Yes, Your Honor.
Yes, Your Honor.
Yes?
Yes, Your Honor.
People have their witnesses available the 18th?
We'll try for that date.
Preliminary examination in person. August 18th, 2026, 9 AM. That's before me. Before me. I'll also hold the bond violation hearing at that time, but at this time, the defendant's bond, given everything that I heard, I don't believe that the defendant has been in compliance, certainly not with community corrections in terms of providing everything. His bond is revoked, defendant's revoked.
All right.
Understood, Your Honor.
Branch count, we can do it up here. Court does call the cases of Chopra and that's home.
Good afternoon, Your Honor. Raymond Cook to the people.
Hey, good afternoon, Your Honor. Good afternoon to your staff. My name is Amir Macklin, representing Messiah. Shown as president standing to my right.
John Shea, Your Honor, on behalf of Ahab Chopra, who is on screen somewhere.
Top right, I see you.
Oh, there he is.
Oh, there he is. All right. State your name, sir.
Ahab Chopra.
And your name, please.
Job to show now.
All right.
Maybe approach, Your Honor.
You may. All right. On this record should reflect we've had a bench conference in this case.
Your Honor, Mr. Chopra, with his, I'm co-counsel in this case, of course, Jonathan Sachs is also a counsel and has done most of the heavy lifting here. As a result of that heavy lifting, Mr. Chopra has paid to the University of Michigan in excess of $6,600 is, I believe, the number. in restitution for items that they claim were not properly obtained by him as part of a student club there. So all loss has been made good. The university has been full. Regardless of there is some dispute, I would say, between whether Mr. Chopra was criminally or his co-defendant were criminally responsible for the loss that the U of M claims it has, but in any event, it has been they have been made whole, and it consistent with similar cases in this court where this kind of a charge is brought and restitution has been made and cases are dismissed. We are requesting a dismissal.
I join in on that motion to dismiss as well, Your Honor.
All right. Court believes that whether court doesn't speak to the procedure that's been invoked resolving these cases and certainly not getting involved in that. But the one thing that will happen is everybody will be treated the same. Everybody will fairly, given all of that, the court believes that given at least even one case that happened today, as well as that, the court is going to dismiss these matters. Cases are dismissed.
Thank you.
Thank you, Judge.
Thank you.
Thank you. Now, all of these people are here with them, so you guys can leave. Crowding the place up here. Yeah, this is gonna take a minute. But I can't get anybody in. Where Miss Keebler, I saw.
Sure, Your Honor.
Yeah, I saw her. Okay. She's right there. I can call that one. The court does call the case of People versus Lisa Keebler.
John Shea, Your Honor, with and on behalf of Ms. Keebler. Lisa, can you state your name for the record?
Lisa Keebler.
Your Honor, I spoke with Ms. Phelps about this. The treatment team is putting together a proposal and we intend to get that to Ms. Phelps as soon as that is done. The lead on that is out of town this week at a conference. So we're asking for an adjournment to September the 3rd.
To September.
September the 3rd? Yeah. Is that Thursday?
Without objection, probable cause conference will be adjourned September 3rd, 2026, 9 a.m.
Thank you, Your Honor.
Bond continued.
Thank you. Thank you, Ms. Phelps.
Court calls case People versus Leah. Is it Angstadt? Dates, he's.
Yeah, I got the rest.
She here.
I don't think so. That's what I'm saying. After seeing what happened the other day.
She is approaching.
It's in the backbones in my.
Okay.
It left before I came out.
Who's speaking?
Your Honor, as to the PCC, we would be requesting a brief adjournment due to the alleged bond violation. And then we would ask to be heard, I guess, as to violation, and then as to bond when appropriate.
Your Honor, I believe the court isn't receiving a bond violation report. It does indicate that the defendant is testing positive for cocaine. Great concern to the people, other than positive tests for cocaine, are for communications with community corrections, where she's indicating that because the gallbladder has been tested positive for cocaine. The reason that I bring that up to the court's attention and want to make that part of my bond argument is it does show a lack of insight into any potential issue if we're blaming a physical condition that could not possibly cause a positive test for cocaine. It just is, it's further evidence to the people of lack of insight, lack of control. So I am requesting that this time for bond be reversed.
Your Honor, Ms. Eichstadt does understand that the lack of a gallbladder would not necessarily result in a positive cocaine test. She does, however, worry that test could be a false positive due to her opiate use, that she does have a prescription for an opiate use, that she has been using that.
Weeks in a row?
It was over 10 days, Your Honor. It was 3 tests in 10 days.
Okay. 3 false positives.
Your Honor, Ms. Eichstadt would admit to the cocaine use for the first test that she had used prior to arraignment. But she has indicated to me that she ceased to use once being arraigned.
And we do know the half-life of cocaine, right?
Yes, Your Honor.
Yeah.
She did pay to get the test sent in. She went today before she came to the court today in order to get the test sent in for belief that it could be a false positive. So that is her request to the court is.
I know I know it was framed on 7/21. 7/24, she missed a test. 7/25, she was positive for cocaine. 7/29, positive for cocaine. 8/4, positive for cocaine. I know I don't record. I have never seen any study or evidence to support that a prescribed opiate would come up positive for cocaine in a urinalysis.
Your Honor, Ms. Eichstadt has indicated that she has not used. So
that what?
That she has not used since she was arraigned. So that is her position as of today.
Yeah. Okay. I'm not taking her plea today.
Oh, I'm sorry, I should have said, I did communicate to the defense counsel via email that the offer is withdrawn at least temporarily until we get some more positive.
Got it.
I apologize.
No, it's okay. I'll adjourn her probable cause to August 13th, 2026, 9, as well as the bond violation hearing. We should have the results back if she paid by then. Bond violation hearing, pending that, her bond is revoked. Defendant remained.
Your Honor, she did, for the record, she did just state she would be willing to take a test today and is confident it would be negative, but understand the court's position.
She can go. Remand. Court calls case People versus Darren Braggs.
Good afternoon, Your Honor. Trovia Star. On behalf of Mr. Braggs. Mr. Braggs, could you state your name, please?
Darren Braggs.
This is his PCC.
I know.
I have his.
I have them all day.
I have his. That's his daughter. That's your daughter, right? Yeah. That's his son.
That's his daughter that he was yelling at to stay in the seat. No, I'm kidding.
Oh.
Go ahead. I'm sorry.
Discovery is complete. I looked at him like, what was it?
You should have seen his face. He's like, oh no, what's this crazy man gonna do? Yeah. All right.
Discovery is complete. I have reviewed everything. We're asking to set this for an exam. And if possible, if this can be set on the.
Are you, whoa. You're gonna pick a date?
I asked earlier.
Off this bench, sir. No. What date?
The 20, if possible, the 25th.
Are people gonna have an objection to that? Discovery is complete.
Yes, Your Honor.
Who would have their witnesses available 25th? I'll set preliminary examination, August 25th, 2026, 9 a.m. before Judge Fresh Hour.
Thank you, Your Honor.
Thank you, Your Honor. You're welcome, sir.
Have a good one.
Bye, little one. Hold it. Are those all his? The two? Oh, he didn't even acknowledge the little one. Let me see the little one's face. Boy, you are so lucky. Look like mama, because if you, I don't know what. You guys take care. All right. Court calls the case, People versus Destiny Heller.
Good afternoon, Your Honor. Raymond Cook for the people.
And Assistant Public Defendant Nicholas Bukovich on behalf of Ms. Heller, who should be appearing via Zoom.
There. Your name, ma'am?
Destiny Heller.
Okay. I have before me a plea form that indicates she'll be pleading guilty to the charge of possession of a firearm in a motor vehicle to 90-day offense. Upon a successful plea to that charge, count one would be dismissed. They're also agreeing, there's a sentence agreement, sentencing under HIDA with a minimum 6 months probation. That's the court's full understanding of the agreement.
That's correct.
Yeah, that's correct.
Yeah. Thank you, guys.
Have a great day.
All right. Hang on. Ma'am, could you raise your right hand, please? You solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
State your name, please.
Destiny Howell.
All right. Ma'am, it is this court's understanding that you are going to be pleading guilty to the charge of improper possession of a firearm in a motor vehicle. That's a misdemeanor, punishable by up to 90 days in jail, $100 fine plus court costs, and mandatory forfeiture of the weapon or device. You understand that?
Yep.
Okay. Still wish, I should also advise you that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Barr in the 1482 District Court. You understand that?
Yes.
Still wish to plead guilty
Yes.
to that charge? How do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes.
Signed or had cause to be signed an advice of rights. Is that correct?
Yes.
Any questions regarding those rights?
Nope.
No?
No.
Do you understand that you're waiving or giving up all the rights contained on that form?
Yes.
Understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily and of your own free will?
Yes.
And also because you believe that you are indeed guilty of this offense?
Yes.
On the date of February 20th, 2026, at the location of Rossendale Road near Willis in Augusta Township, Washington County, State of Michigan, were you in a motor vehicle?
Yes.
Did you have a firearm in that vehicle?
Yes.
Where was it located?
In the center column.
Was it loaded?
No.
All right. Do you have any authority to carry that pistol in that fashion?
No.
All right. Ma'am, I do have to apprise you that if between the time I accept your plea and the time of sentencing, if you commit misconduct as defined in Michigan court rules, you would not be entitled to withdraw your plea in this matter, and the court would not be bound by any sentence evaluation or recommendation. You understand that?
Yes.
Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
None from the people?
No, Your Honor.
And have I complied with the court rule?
Yes, Your Honor.
The defense is satisfied, Your Honor.
Court will accept the defendant's plea to count two. Count one is dismissed. Sentence investigation and report is ordered at 1482 probation. Sentencing will be
August 25th at 10 a.m.
August 25th, 2026, 10 a.m. before Judge Barr. Bond will continue. Thank you.
Thank you, Your Honor.
Court calls case People versus Samantha Henry.
An assistant public defendant, Nick Bukovich, on behalf of Ms. Henry, who should be appearing via Zoom.
Samantha Henry?
Oh, there she is. Okay. And what are we doing?
Your Honor, I was asking for adjournment. I was able to get in contact with my client this morning, so we have not had time to discuss the case.
All right. I'll adjourn this matter out to September 3rd, 2026, 9 a.m. Bond continued.
Thank you, Your Honor.
The court calls case People versus Laura Smith. Yeah. I
Oh, that's fine.
hate when I call cases in French.
Yeah.
Yeah, Fatima Dadish on behalf of Miss Smith stepping in for Ms. Gaines. Before she stepped out, she let me know that there was a miscommunication on our end that she will be here at 3. Which it sounds like we're gonna be here until then anyway.
Wow. Oh.
Not because- Judge, I'll.
No.
I'm
I'm sick and tired of it.
you pass on it.
Her report could have been county at 3 o'clock, it turns out it was not, she'll be here at 3 o'clock, clock is a register.
Yes, of course. That's not gonna walk out.
No, it's okay. That's why I was like, let me ask.
Was she?
That's what it's- of
She on Zoom?
course. Oh, it does say her name on Zoom. Maybe she decided to sign in. Yeah.
Okay.
All of that was for no reason.
Which is a lot of what you do.
Yeah.
All right. I know. You come at me, I'll come at you. All right.
Your Honor, we are working out Joy Gaines, Senior Assistant Public Defender.
All right, Ms. Smith, can you state your name? Huh? Yeah, Ms. Smith, can you state your name?
Lord Smith, I'm sorry, I got a spotty signal here in Saginaw. It keeps going in and
Okay.
out.
It's okay. You're asking for an adjournment?
That's correct. We are close to coming to a resolution with regard to her participation in recovery court in Saginaw.
In Saginaw. I'll adjourn it to September 3rd, 2020.
Thank you.
Is that a Thursday?
Yes.
Yes, it is.
Can it be in the morning? Because we have recovery court every Thursday in the afternoons.
Ms. Gaines, if you can send that request to Ms.
I sure will.
Wilding, we'll try to accommodate the best we can, okay?
Thank you.
Thank you. Listen, recall the case of the people versus Jerry Doss.
Good afternoon again, Your Honor.
This is a public defender, Zach Vinue, with on behalf of, or I guess on behalf of Mr. Doss. Your Honor, Mr. Doss, I don't believe he was ever here. However, he did. I got a message from our legal assistants that he called our office about 15 minutes ago and is now walking to the 14A2 district court to try to log on. So I guess I would ask to pass. Yeah, I would ask to pass the.
You know what? I'll pass it because you're not Bellinger.
Yeah, thank you, Your Honor. I just much appreciated.
If you were Bellinger, I'd just say no. I don't think that's how it works, Bellinger. We're okay. We can all have our dreams. All right, we are well behind because of some things that happened in the court, behind in the block. I'm going to take a brief break, come back, and then we'll go into the next block. Your one client is here. I think that might be Mr. Douche's client. All right, thank you. Court's in recess.
All rise. All rise. Company District Court is now back in session. The Honorable Chase Simpson, President.
Maybe see. Court does call the case of the people versus Jules Calphone.
Good evening, Your Honor, I'm Elvis for the people.
Your Honor, Sunita Dadamani on behalf of Mr. Calhoun.
Was there anything from either side or did they? Well, before you begin, let me just say a couple of things. So that I'm not sure that people sometimes understand how courts work. But I'll speak certainly for this court and this judge. The decisions that the court has to make are certainly balanced upon certain things. I've received a number of communications not coming through the parties. I've shared those with the parties. But people should understand that those don't sway me one way or another. The court's decision, while we live in a country that's democracy, so it says, my decision is it's not a democratic thing. I don't go on votes. I don't, while I appreciate people's opinions about things, some of which I may vehemently disagree with. The way to get that is those that may want to get things through the prosecutor's office, who feels that they're on that side of the issue. There are victims advocates and others that can get that communication to the court, and in a manner in which counsel can look at it and determine whether or not that's something that should properly come before the court, because they know. And from the defense side, same thing. So while I appreciate you guys wasting the paper and the ink, those have no bearing on me. I'm going to make my call based upon what I see, what are the facts of the case. It also, I will just say, I read every one of them. And with all due respect, some of the comments, and I say this, and with all the respect that I can possibly muster, that they're not factually, things aren't factually based. The facts that some of these things are predicated on don't exist in this case, which is sort of makes a lot of it, in my mind, sort of statements of ignorance as to where they're coming from and conclusions that then come through that. So I would suggest to those that may want to write to the court or information that they work through the appropriate ways of doing that. Send it to counsel. Let counsel decide if it should come before the court, because otherwise, again, it's not going to have any bearing on me. Certainly not at this stage. I also am troubled because we are at a stage where the court is just dealing with bond consideration. And there are statements that are made that have flipped everything about American jurisprudence on its head. Because there's this presumption that Jules is guilty. Folks, understand something. He has not been convicted of anything. Nothing has come before the court that has rendered any decision about any bit of his conduct. And I don't know myself, in terms of the evidence that's there, whether or not that evidence is going to be sufficient that a conviction would even occur. But everybody is quick to just presume he's guilty. And maybe people should take a moment, based upon what I see in these letters, and reflect upon that. Because some of this, while they try to couch it in other terms, and I say this in a respectful way to Jules and others like him, some of the presumptions are being made that he is something because he's different. It's not how we work. That's not how this court works. That's not what we don't do things to people because they may be different, because they may conduct themselves in different ways. I am looking solely at the allegations that are in the case, the facts, and the facts of the case. I'll emphasize that word, the facts of the case as they relate to these particular charges. So I would ask that you just refrain from doing that. If you want to send it, you send it. They're going to end up the same place that everything else is, and going to have the same impact on this judge. I've been doing this a while. I know what I'm doing. I get it all. And I will just say as a personal note, I'm dismayed as a family of educators and my being an educator and professor myself with some of the presumptions of people who presume to be or say they are educators. Because sometimes the primary job of an educator is in a room full of kids or a room full of students. You have to deal with those that are of the least and those that are of the highest. And you have to do for both of them. And some of the statements that I see from some of the teachers, it distresses me, being a product of the Ann Arbor public school system myself, that there are teachers that believe that because Jules is who Jules is, it seems they don't want to deal with children that may be like him. That is what I see. Ma'am, you can shake your head all you want. If you want to talk in my courtroom, you don't get to talk here. And you can take yourself out into the hallway. You hear me? Am I understood? So what I am going to do and what I've elected to do is to adjourn this hearing. There may be things that I may request of counsel, such as a full threat assessment to figure out where this is and what threat, if you will, Jules actually poses. So I may be requesting that. I haven't made that final decision. I'm going to adjourn the probable cause hearing and a determination on the bond and its conditions. I'm going to adjourn that to September. I was going to do the 3rd, but 10th. The 3rd doesn't work for council, so I'm going to adjourn this to September 10th, 2026.
Thank you, Judge. May I request that it be in the morning section of the
I
docket?
want it morning.
If it's possible, I have to be back in Detroit at 5, and I'm not sure I could make it if we set it for the
If it's
afternoon.
like today, yes.
Thank you, Judge.
Ms. Valtez, you have any?
Not at all, Your Honor. That's.
I'll set it at 9, and maybe Ms. Weidling, we could try to make it toward the noonish hour so we can get through our block of chaos and then get.
Judge, appreciate accommodation.
Is there anything else?
No, Your Honor.
No, Your Honor.
All right, bond will continue. Thank you. Thank you, Jules.
Thanks, bye.
Bye-bye. 14A. Ann, thank you very much. Anna, thank you very much. Lily, thank you very much. Rasan, thank you very much. I don't know if Mallory was here. Thank you, Mallory. Mr. Bates, thank you. 14A stands adjourned.
All rise.
My name is Todd Russell Perkins, P 55623. Mr. Bowman, can you announce yourself?
Cody Bowman.
Okay, thank you.
Thank you, sir. All right, what are we doing?
Me or you?
I'll go for it.
Okay.
Counsel, I have a potential resolution. We need to run a new potential resolution through the victims as the victims right to crime get their position. We could have a 2-week adjournment in order to have that conversation.
2 weeks would be good.
Yes, Your Honor.
During this matter to August 20th, 2026, 9 a.m. Bond will continue.
Thank you so much.
All right, thank you.
Thank you.
Thank you, Mr. Perkins.
All right.
Always
I'll be in
good to
touch,
see you.
Mr. Same here, Your Honor.
Court calls the case, People versus Faith Askew.
People, Your Honor.
I'm Patrick Wilson, Public Defender, on behalf of Faith Askew, who's present. Thanks, please state your name. Faith Askew.
All right. Where are we on this case?
Your Honor, I'm unsure as to what exactly we'd like to do with PCC today, but I would like to first address the bond.
What were we doing with the PCC?
We were going to be requesting an adjournment for additional discovery.
Probable cause conference, I will adjourn it to August 20th, 2026, 9 a.m. as found.
Yes, Your Honor, it's come to my attention that last night, at the behest of defendant, I believe 5 subjects went to the home where the minor victim in this case was located, with the instruction to take those children. I provided with the report of that, as well as some text messages, which I believe are between defendant and the minor victim listed in this case. Those text messages, and I see the report is thumbing through them right now.
Yeah, no,
Those people are coming to get that minor victim, telling the minor victim not to say anything and the things of that. Like, I do think that given the severity of this case, that a remand would be appropriate given what is fulfilled. I would also ask that should the court decide to remand the defendant, that defendant's phone privileges and text privileges be revoked, given that it's clear from these text messages that the defendant is not able to simply abide by that contact order.
Thank you, Your Honor. My client, she is a mom. She's been raising these her two children since birth, both her daughters. The individual that the kids are with, they were there for a play date, and something got reported to the police. This is not somebody that is in any way, shape, or form related to her. She's actually the friend of her ex-boyfriend. And so she recognizes that there was a much better way to go about doing what she was intending to do, which was to get the kids placed with someone in their family. And she recognizes that she should not have had any contact with them. She doesn't have a.
Why would she even? Go ahead.
I understand.
Mr. Bates.
She's terrified for her kids and would really like to see them. It's been over a month since she's had any contact with her babies. And so we would ask the court to consider, setting either a bond or giving her some type of tether so that she's reminded in a physical way that she can't have contact with them until this case is over. And if someone from her family wants to approach CPS about getting temporary custody while this case is pending, there is a way to do that. That's not what they tried to do. So that's what.
Way overboard. Sending people.
Of course, Your Honor.
And then, I mean, it's one thing, I guess, in terms of communication, but sending people?
I don't think you should talk.
Anything else?
Time that this occurred was well into the evening. It was just shy. Those people went to all stuff.
You would like a hearing on this, counsel, after you have more detailed discussion with your client, but I think you probably already have. But at this point, the defendant's bond is hereby ordered revoked. Defendant, because of these text messages, I mean, this is just whatever. I am going to order that her phone privileges and text privileges are also revoked. All right. Thank you. She's your man.
I understand.
What was that?
The 20th. People versus Juan Howard. Counsel, you're gonna unmute?
Yeah.
Oh, come on, counsel. I expect this from defendants. What are you doing? No, you can talk all you want. I can't hear you. You have staff there, teenager, they'll know how to do it. Oh, I'm supposed to read that? My eyes are, jeez, oh, Pete, man.
All right,
What?
Judge, I'm not
He
that
hasn't
old.
shut down. No, he doesn't. He finally found it.
No, I think your clerk shot something to me that said unmute. I kept clicking. This ain't the first time. I've done hundreds.
Okay, all right. So was that you, Ann? Thank you, Ann, because he would have sat there all day and night. We'd still be here at midnight.
I'd see you at 7 o'clock tomorrow morning. Yeah.
Exactly. All right. State your appearance, counsel.
I don't know if I want my name out there. Bill Clovis, P38434 on behalf of the defendant. Sir, would you please state your name?
Juan Howard.
All right. Okay, what are we doing on this case?
This is the first time it's up. He was just arraigned the other day. If we could have, I don't have any discovery yet, at least I haven't seen it. Could we have a short adjournment? And I say August 27th, since you said that date before. Give me a chance to get the discovery and review it.
Not opposed, Your Honor. Defense counsel, once we receive your appearance in my office, there's an email address you can send it to. We can release the discovery. Would ask to be heard on bond before we're done today.
During the matter to August 27, 2026, 9 a.m., or as your invite indicates, yes, as to bond.
Your Honor, in this case, we do not yet have a BAC. This just happened about a week ago. So it was July 27th that this OWI occurred, and we charged under the influence theory. I'm very concerned. I believe the defendant has been ordered to a sober link. I'm going to do our request for a scram tether. This is the defendant's 5th or 6th OWI. His priors are from 1994, 2002, 2014, 2014, and 2022. Notably, the 2022 OWI was a third subsequent, and it looks like he completed his probation in November or December of 2025. So fairly recently. So I am going to review our request. I don't have for the court the BAC, but I will let the court know that the Northwest Township Police Department did observe the defendant in a ditch operating the vehicle in a runoff, and it's otherwise a clear, sunny, fine day or no notification. So I am concerned that there was an element of bad driving and we haven't mentioned priors.
Your Honor, if I may.
Yes.
My client, I asked him, he said he says that he was never informed about a sober link. If a sober link needs to be done, Your Honor, he'll do it. He works.
Well,
go ahead.
Hold it. He's not on any testing?
I am.
Hold on. What kind of testing are you on?
You got to blow into the thing?
Oh, that's sober link.
Oh, yeah, that's what I'm.
Oh, he is on it.
Yeah.
Okay. How many times a day do you blow?
Twice a day.
Twice a day?
Yes.
Okay.
So with that record, and we'll await the PBC, I won't make this necessarily permanent, but the defendant's to report to community corrections. He's to be switched to a scram tether.
That's on your ankle.
So you'll need to turn in the sober link device. They'll fit you with a scram testing unit. Okay. You need to do that within 24 hours.
All right. He works 5:30 to 2:30. So tomorrow you'll be able to take care of it. Okay. Thank you, Judge. We will do that. I appreciate it.
All right. Thank you. We'll see you on the 27th.
All right. Thank you.
Thank you.
Hey, I know how to shut it off too. Wow.
Court calls the case. People versus Aliyah Hatka.
Osley Victor on behalf of Aliyah Hatka.
Her name?
Aliyah Samir Hatka.
Thank you.
And Your Honor, we are seeking to request that a preliminary exam be made.
All discoveries complete.
To my knowledge, Your Honor.
All right. Would people have their witnesses available on the 18th?
We'll do our best, Your Honor.
Preliminary examination will be set August 18th, 2026, 9 a.m. before Judge Moore.
Thank you, Your Honor.
All right.
All right, what was that date?
Continue.
The 18th.
Pardon?
All right, thank you.
Court calls case People versus Eric Jackson.
Attention, fellas, for the people.
Chairman Dadush, on behalf of Mr. Jackson. Jackson, can you please say your name for the record?
Eric Jackson.
Your Honor, actually, I confused an earlier case with this case. This is a case that we got mitigation on yesterday that we would be asking for a short adjournment on. I've already talked to Ann and Ms. Feltus about the other ones. No need to worry about that.
So correcting that part.
So I,
Will the 20th work for you?
that should work with me. It's I probably, yeah, Ms. Feltus gave it.
Okay. Adjourn the matter to August 20th, 2026, 9 a.m. Bond continued.
Your Honor.
Thank you. Court calls case People versus Jalen Johnson.
And Assistant Public Defendant Nicholas Bukovich on behalf of Mr. Johnson.
We don't have it.
Filed because the defendant was deployed.
Oh,
I'm not sure if defendant had the contact.
yes.
Yeah, I'm stepping in for APD Bernie. We have not been able to have contact, so we were going to ask for an adjournment as well because we understand that for a while in this file he has been deployed. So obviously it's been also difficult for defense counsel to have contact with someone who's deployed.
Well, and I do have here that my last note was that he was deployed to the Middle East, and it just saw a report where those regrettably they're being extended. So I don't.
So yeah.
Hopefully they'll be able to make contact with him at some point, but we're okay with the adjournment for now.
Given my friends, I don't know that I don't know that keep trying, but I don't know that that's going to happen.
And I do have a green sheet, Your Honor.
Pardon?
I said I do have a green sheet, Your Honor.
I will adjourn this to September 10th.
Thank you, Your Honor.
Your Honor.
Court does call the case People versus Marco Jones.
And Assistant Public Defendant Nicholas Bukovich on behalf of Mr. Marco Jones, who should be appearing via Zoom.
Jones?
Yeah, I can't get the video on.
I do believe his video was on earlier, Your Honor. I can see he just can't get it in there.
You got it. Okay, state your name.
Mac Anthony Dodd.
Thank you.
Your Honor, to be asking for adjournment to look into potential outstanding media discovery. And I do have a green.
Adjourn the matter to August 27th, 2026, 9 a.m. Bond continued. Court calls case People versus Xavier Lawson.
Mr. Lawson, you get this beginning for the record, please.
Xavier Lawson.
Judge, I do have a green sheet. We are in negotiations. I think we're close to a resolution in this.
Adjourn the matter to August 27th, 2026, 9
You judge,
Right.
August 27th.
27. Court calls the case of People versus Javante Lett.
I'm sorry. Assistant Public Defender on behalf of Javante Lett is appearing via Zoom.
Lett, state your name.
Javante Lett.
Thank you. What are we doing?
Your Honor, we're requesting an adjournment for further discovery.
Adjourn the matter to September 3rd, 2026, 9 a.m. Bond continued.
Thank you.
Court calls the case of the People versus Ebony Maben.
Public defendants, now here, really, Your Honor, on behalf of Ms. Ebony Maven, who is on Zoom, have a green sheet, Judge.
Maben, can you state your name, please? Ebony Maben?
Come on.
I don't have her. I know she was signed in earlier. I did see her, but I look.
I can try and give her a call, Judge.
I'll tell you what I'm gonna do. I'll adjourn it out to the 20th.
Okay,
Just contact her. I did see her name signed in her.
thank you so much, Your Honor. I'll let her know right now.
Court calls the case, People versus Michael Magaha.
Assistant Public Defendant Nicholas Bukovich on behalf of Mr. McGaha, who is now approaching.
Your name, sir?
Michael McGaha.
Sorry. Oh my God.
Hello? Where
Hello,
are you?
sorry. Oh my God, what's going on? Oh my God.
Give me your name.
Hello?
Sounds like she
Ebony
can't hear
Maven.
us. Okay, never mind.
Right, your case, I knew you were here in a way, so I adjourned your case to the 20th.
Okay, sorry. Thank you so much, Your Honor.
You're welcome. Take
Okay.
care. Go ahead, we were on this.
Yes, Your Honor. Your Honor, at the time, we would be requesting an adjournment in this matter to look into the potential of getting into sobriety court. I'm also prepared to request a bond violation when the court is ready.
Yeah, well, it's a progress report and you can't miss your test.
Yeah. What do you want me to explain down on your behalf, sir?
Bob me?
So I did speak to Mr. Magaha about those weight tests. Unfortunately, as you see, there were some earlier missed tests for the drug testing. That was due to him unfortunately losing his employment, being laid off. He was a temp in the company he was working for, so when he began layoffs, he was one of the first ones cut. He does have gainful employment now, will be able to go and do that. When it came to the late test, he originally used to work midnights at his old company, and now it's switched to the morning shift, working from 7 a.m. to 3:30 p.m.
Trying to talk me into doing something to him.
I was prepared. I was prepared for an argument. I was, prepared, Your Honor.
I mean, you keep talking, it just looks worse. I was just gonna give him the benefit of the doubt, he's gonna get it straight.
Okay, now stop talking, Your Honor.
Then you're done?
Yes.
Okay, Bond, we'll continue. Thank you. Thank you. I didn't today? Oh. Because I was listening to Bukovich. August 27th. Thank you, sir. Court calls case, People versus Scotty Minardi.
Good afternoon, Judge.
Pedro Dados on behalf of Mr. Minardi. I don't think he said his name.
His name, please, Minardi.
Can you repeat that?
Yeah, I can see you. State your name.
Oh, my name is Scotty Minardi.
Thank you.
Your Honor, we don't have video discovery on this case yet. We asked for an adjournment for that purpose.
Adjourn the matter to September 3rd, 2026, 9 a.m.
Thank
All
you.
right. Thank you.
Thank you,
Bond,
guys.
continue.
Reach out, Mr. Minardi.
Okay. Court does call the case, People versus Nasir Abed.
Assistant Public Defender Jay Bellinger on behalf of, but not with Mr. Abed, Your Honor. Mr. Abed was recently sentenced in Wayne County. He is an MDOC for the next 2 years. He's currently located at the Charles Igler Reception and Guidance Center. Sounds nicer than it is. So I imagine that. So I.
Just looking for an adjournment to try to see what's.
Thank you, Ms. Full cause conference, September 3rd, 2026, 9 a.m. Bond continued.
Thank you.
I said September 3rd. I said it, Frank?
Yep.
Thanks for sticking up for me finally. Like yesterday. Court calls the case, People versus Andrew Pat.
I should file this for the people.
Good afternoon, Your Honor. Charlotte Stefan on behalf of Mr. Patton, who does not appear to be here.
Oh, good seeing you, Miss Sam.
Thank you. You as well, Your Honor.
He's not here. Bench warrant will issue for defendant failure to appear. Bond will be setting him at a $10,000 cash surety.
Thank you, Your Honor.
Court calls the case, People versus Trayvon Pittman.
Good afternoon, Your Honor. Raymond Cook for the people.
David I. Goldstein appearing on behalf of the defendant. Pittman, state your name, please.
Trayvon Pittman.
Thank you. You're just
Your Honor,
looking for an
Yes, Your Honor. Yeah, I did receive the discovery today, but I have not had a chance to review
We put your other cases over to the third, did we?
it. One to the third, one to the 27th, so either one, Your Honor.
All right, I'll put this one over to the 27th then.
All right, Trayvon, I'll be in touch.
Okay.
All right. Bond continued. Thank you.
All right. Thank you, Your Honor.
Court calls case People versus Christopher Whitmore.
Afternoon, Your Honor. Rich Davis appearing with Christopher Whitmore, who's president of Perry Zone.
Whitmore, state your name.
Christopher Whitmore.
Oh, there he is. Okay. All right, what are we doing?
Judge recently came in on this matter. Substitution was signed yesterday. I received a discovery, need some additional time in order to review it and decide how we're going to proceed.
Okay. Adjourn this matter out to September 3rd.
Is that Mr. Davis?
Yes, it is.
Mr. Davis, if you get a copy of your appearance to my office, we'll get you the videos as well.
Okay, thank you.
All right, September 3rd.
All right, thank you, Your Honor.
You, court calls case People versus Davion Smetler.
Good afternoon, Your Honor. Vote for the people.
Smetler,
Yes, Your Honor.
here you are.
Here somewhere. So,
Been one of those days. I'll pass this matter when he shows back in here and I'll call it back up. I'll pass it, sir. I'll call you back up in a moment as soon as we find your attorney.
Okay.
Court calls case People versus Drenda Miller.
Good afternoon, Your Honor. Reading for the people.
Assistant Public Defender. Tanaza Ikeri Adams on behalf of Miss. I think it's Drenda. It starts with the judge.
The more you talk, the slower you walk, you know, appear. You'll eventually get here. That's okay. I saw the guy take off going to go look for her.
She was copying judge and she stepped out.
We should see her.
Ms. Miller, state your name for the record.
Drenda Miller,
Is that with you?
my great nephew and my husband.
Which one was in the short? He just took off running out of here. That was you. Okay. Heard your name and he was flying. All right.
To the bathroom.
Okay.
We're setting this matter for preliminary examination, please.
Discovery is complete.
To our knowledge, Your Honor, yes.
Are there witnesses available the 18th?
For best, Your Honor.
Set the preliminary examination August 18th, 2026, 9 a.m. before.
Okay.
Judge Moore.
18.
Thank
Thank you
you.
so much for you.
Court calls case of the People versus Marcus Mudar.
Defendant Lebo for Mr. Mudar. I haven't been able to reach Mr. Mudar, Your Honor.
You don't know where he is?
I'd like to, but unfortunately I don't.
If I hadn't said anything, you just sit here and stare at me all day, wouldn't you?
No, Your Honor.
Okay. Bench warrant will issue for defendant's failure to appear bond. We'll be setting him at a 10,000 cash surety.
Thank you.
Court calls the case of the People versus Deshaun Murray. Deshaun Murray. Where's Cannon?
Assistant Public Defender Hannah Apple appearing on behalf of Deshaun Murray. Your Honor, we're asking for an adjournment.
Yeah.
I don't think it.
Oh,
Hi.
actually, yes, in the Jackson County Jail.
oh,
Oh. Like those accommodations better. All right. We haven't been able to check behind link, but I'll adjourn it out to the the 20th. Well, I'll turn it up to the 27th. Let's see if we can find him. And
Thank you.
Thank you.
Court calls the cases of the people versus Robin D. Nobles, 3 cases.
Assistant Public Defender Nicholas Butkovich on behalf of Ms. Nobles.
Hello, Ms. Nobles. State your name, please.
Hi, Robin Nobles.
How come Butkovich is having to cover for you?
I didn't realize we were in the 3 o'clock here on that.
What?
Completely my mistake. No excuses. Asli Bashir on behalf of Rob Nobles. Your Honor, we're requesting an adjournment. Just so I can speak with Ms. Nobles. Is located at a treatment facility, and I haven't gotten a chance to speak with her about her case.
August 27th, 2026, 9 a.m.
Thank you.
Bond continues.
Thank you, Your Honor.
Thank you, Your Honor. Thank you.
Court calls the case, people versus Dylan Reynolds.
And on behalf of people, Your Honor.
Assistant Public Defender Jay Bellinger on behalf of Mr. Reynolds, who should be in appearance via Zoom. Mr. Reynolds, can you please unmute yourself, state your name for the record?
Dylan Reynolds.
And Your Honor, we are seeking to set this matter for preliminary examination. That said, I have spoken with Ms. Zenda. I think that given the fact that the parties both live in Pennsylvania and my client has some work stuff, we were asking, I'm hoping for.
Live in Pennsylvania?
Yes.
Steelers or Eagles fans? Depending on where I said it.
Mr. Reynolds?
Yes.
Are you a Steelers fan?
Oh, no, I'm a Seahawks fan.
Okay.
Even worse.
Okay. Your Honor, we were hoping to set the date for the preliminary examination on September 1st, if the courts would be available for that.
You want September 1st date? All right. So preliminary examination will be set September 1st, 2026, 9 a.m. Mr. Douche, before you leave. 9 a.m. before Judge Perry.
Thank you.
Bond will continue.
Thank you.
Mr. Douche, to approach at a separate matter.
Oh.
Yes, ma'am. So demanding. Court calls the case, people versus James Robinson.
I felt the people.
Assistant Public Defender Jay Bellinger on behalf of Mr. Robinson, who should.
What? Hold it. Coming up to do the case?
Oh, I'm so sorry. Please.
She ran all the way down that aisle. And
by all means.
And she just stopped and headed the other way because.
I'm glad she's here and available.
Wow.
Not trying to take opportunities away for her to learn.
Yes, you were.
Fine.
Yes, you were. That's okay. I was going to let you do it anyway. Went back, sat down, bowed her head.
Aw.
Almost in.
Sorry, Andy.
I was in tears. Go ahead.
Your Honor, Amy Lucas requesting permission to practice pursuant to Michigan Court Rules 8.10 under the supervision of Assistant Public Defender Jay Bellinger.
Pick somebody else to be under supervision of, because he should have done that to you. Hannah Apple, go ahead.
Okay.
Permission to practice is granted.
Oh.
Okay, what are we doing in this case?
We're seeking to adjourn for continued negotiations.
Okay. That objection. Adjourn the matter to September 3rd, 2026.
Thank you.
Thank you. Thank you for appearing.
Thank you.
For appearing. You did a great job.
Was that for me? I'm sorry, James.
What? No. It is adjourned, sir.
All right.
September 3rd.
Thank you.
All right, thank you. Court calls the case, people versus Ashley Tree.
Ashley calls the people.
Asli Bashir on behalf of Ashley Reed.
Your name?
Ashley 3.
Your Honor, we previously adjourned the matter for screening for specialty court because of Ms. Reed has recently moved, and so we are seeking screening into another special court. I'm requesting
You gotta go to another location, try to get her
yes, Your Honor.
starting over. All right. I'll adjourn the matter out to September 10th, 2026.
All right, thank you, Your Honor. We've started the process.
92 days.
92?
Yes.
Congratulations. That's happier?
Oh, yeah. I feel like a different person.
All right. Well, you make sure to keep up the good work.
Oh,
Okay?
yeah.
It'll be 120 some odd days, but well, no. Yeah, something like that when you get back here.
Yeah.
All right.
Thank you.
Court calls the case. So the people versus Sarah Ward.
Spell for the people.
So actions on behalf of Sarah Ward, who I believe is appearing via Zoom.
Ward, can you state your name, please?
Sarah Ward.
Thank you.
Thank you, Your Honor. We are requesting an adjournment for discovery.
Matter to August 27th, 2026, 9 a.m.
Thank you.
Bond continued. Court calls case people versus Eric Woods.
Yeah, then I'm having.
Enzo Hutchins on behalf of Eric Woods. President, please state your name for the rest.
Eric Woods. Thank you.
Your Honor, we'd like to set this for preliminary exam.
Discovery is complete.